We are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much. Good morning and welcome to the Appeals Court. I'm Judge Milkey. With me are my colleagues, Judge Blake and Judge Henry, and we will be the panel on all 6 cases this morning on this special Zoom sitting. Our first case is Commonwealth v. Condon, 2019 P 722. I want to note, you both are old hands at this, so you know the rules. I just want to emphasize that we have read the briefs and the records, so we are quite familiar with the arguments. So we would urge you to jump into the heart of it as soon as you can. So with that, I will turn it over to Mr. Haynes.
Morning, Your Honor. James Haynes on behalf of David Condon. So the only question for the jury in deciding the rape charge in this case was whether or not Mr. Condon and Alice Bailey engaged in consensual sex. There was ambiguity on this point, and the reliability of Ms. Bailey's testimony was essential to deciding that question. Now, there's a jarring shift.
Correct?
I'm sorry.
Mr. Haynes, you're using a pseudonym, correct?
I am using a pseudonym,
Okay.
yes, of course. So there's a jarring shift in tone between Ms. Bailey's description of the events of the previous evening that occurs in the 2-hour period between when she begins texting with the first complaint witness and when she actually makes the rape allegation. That inconsistency goes right to the heart of her credibility, and it's the crux of the Commonwealth's case on this charge. It was an error to exclude the full text exchange.
Mr. Haynes, what's inconsistent about it? I'm looking at the excluded messages. There's nothing in there that says she had consensual sex. There really is nothing there about sex. It certainly is leading up to what transpired at that house, but I'm struggling with the inconsistent piece.
So I would suggest that it's the tone, the way she describes the events from 11:45 till noon when she's having the first bit of conversation versus the description that she gives from 1:48 until 2 p.m.
And
it's a
tone from a cold black and white record.
Sorry, say that again, Your Honor.
How do you assess tone from a black and white cold record?
In this case, the use of emojis and things like laugh out loud, I think that those are indicative of a shift in tone. If somebody is in their first version of describing an event saying, oh, you know, there are a bunch of naked ass guys in these pictures because I beat them at strip poker, laugh out loud, laughing face emoji, thumbs up. That is a different way of communicating with a person in text messages than would be where she makes just a blunt allegation of, I got raped by David Condon. That I think even though it is a textual exchange and there isn't the sort of, you know, voice change, you can intuit it from the way she is typing and the way she's communicating in that text. It does not require being a little bit familiar with sort of the argot of internet exchanges and how people text and how they dress up their things to convey these sort of, I don't know, intimations, but I think it's there. It can definitely be seen. And I think that the jury would be able to elicit that, or at least defense counsel would have been able to, if it had gone in, been able to, for example, this was going to come in with the first complaint witness, Mr. Pavlakis. She could have asked him, you know, Mr. Pavlakis, what does a crying, laughing face emoji mean to you? What would you take away from that? Or do you know what LOL means? Can you inform the jury what that means? Again, I think probably people would be able to pick up on that, but even though it is just basically as you said, black and white record, there's certainly tone that can be drawn from it.
Counsel, part of your point, I take it, is that under the facts of this case, the partying and the heavy drinking is sort of inextricably tied up in the rape allegations, so that her comments and tone with respect to that is relevant to how she felt about the alleged sexual assault.
I think that is fair to say. I think there is some ambiguity on how much she had to drink. If you do read her description, she says she had, 2 shots of vodka into a pint-sized Polar bottle full of orange juice, and then she had a shot of the tincture that's described, which sounds terrible. It doesn't sound like she had more than that. And she herself says, I may have been somewhat intoxicated, but it's unclear whether or not she's blackout drunk when the sex occurs. I know she later says that she went into the bathroom, threw up, and then, the next thing she knew was she was on the couch having sex. But so I do think there is some inconsistencies within her testimony there as well, which is why, again, her credibility as a macro issue in this trial was something that needed to be fully addressed before the jury. I do think, though, that the earlier stages of the texts are the sort of thing that you would expect a young person to send to their friend when they were saying, yeah, had a few too many drinks last night and had a real good time. And then as the hangover gets worse and the consequences start piling up later on in the afternoon, when she's probably losing her job, that's when she begins to change her tone very drastically. I mean, it's a 180-degree shift, in my opinion.
Counsel, go ahead, Judge Henry, I'm sorry.
Is transcript 3 around page 69 the only place in the trial that the defendant offered the earlier text messages?
I believe so. That is, I believe, the sidebar when they have gone to during the testimony of Mr. Pavlakis, correct? I think
yes. Yes, and I'll commend you for. I'm quite familiar with texting. I have teenagers, but I do commend you for the chart that you included in your brief. That was incredibly helpful. So can you? One of the concerns I have, though, is the prosecution is arguing these are hearsay, and defense counsel never ever says, no, these are not hearsay, right? Do you?
I agree the record doesn't pick that up, but I think the record around the, around that sidebar is pretty fragmentary. There's a lot of, inaudible, can't be heard. I think there is a part where she says, no, these are I'm trying to argue these for credibility and for impeachment, which would suggest that she is trying to say these are non-hearsay. I'm not trying to bring these in for the fact of the matter asserted. I'm trying to bring them in to show her change in mindset, her state of mind, which if it's being offered to prove it circumstantially is not a hearsay usage, and also to highlight some of the inconsistencies that I described earlier, which also would not be a hearsay usage. So I think you can infer from her comments that that's what even though we don't have her saying this isn't hearsay, the arguments that she's making are the sort that a trial attorney would make if they were trying to push this outside of the hearsay rule. I also think from the actual context of the texts themselves, it's plain she's not really offering them for what they assert. The issue of whether or not Miss Bailey is losing her part-time job at a dry cleaner is irrelevant to the trial, or very, very low relevance.
We understand you're saying from the content and from the statements of defense counsel that we should infer she was saying these weren't hearsay. But if we don't agree with that, then what's the standard of review here where the proponent doesn't argue the right thing or oppose the wrong objection, the wrong objection correctly?
So I know the Commonwealth in their brief suggests that this should be reviewed at abuse of discretion. I think actually the proper review for this is prejudicial error or preserved error, even though defense counsel may not be on the record, or at least the record that we have specifically saying hearsay. My reason for saying it should be preserved error is that that seems to be how it is treated by the SJC in Commonwealth versus Parent, which is a case that is factually reasonably similar, I would say almost very similar to this. In Parent, you have a complainant just saying that she was basically fondled by her friend's father. There are some inconsistencies. I'm hoping that time expired is not correct.
That is not correct. It was about 7.5 minutes.
Okay. oof, lost my train of thought there.
Okay, so
sorry.
take a minute because
Parent-
we don't want you to be losing your train of thought. Take a minute when something like that happens.
Parent has, again, inconsistencies between a first complaint by the victim and then things that she says to the detective later on, and I believe actually things that she says on the stand versus what she told the detective. The SJC in that case said that this was something that, again, like this case, goes to the crux of the Commonwealth's case. It was a sexual allegation where the only real evidence that the court and the jury had was the defendant, I'm sorry, not the defendant, the witness's word. So her credibility was a matter that was important enough that it was not something that should just be, I'm actually going to quote it because it's strong enough language. Bear with me. Sorry, they say that these are not it was not a collateral matter that a judge had discretion to preclude. And then they go on to actually analyze the exclusion of the materials at prejudicial error as opposed to abuse of discretion.
Mr. Haynes, I have two questions, one of which follows up on Justice Henry's question to you about what standard of review. At transcript 3, page 70, when defense counsel offered the portion that's excluded, she said that it gives the full context of the text messages.
Yes.
So I'm struggling with the grounds for which they were offered at that time. And then my second question is, because there's a 4-hour gap in between, can you address the Commonwealth's contention that the excluded messages were not within the scope of the first complaint?
Sure. Okay. So as to the first part, I think probably what she was doing there is akin to what I was doing in my brief, which is I believe she made the hearsay arguments first, and you can infer that from some of what she was saying. Addressed that already. When she gets to this goes to the context of them, I believe what she's doing there without saying it explicitly is making the doctrine of completeness argument. That would be looked at by an abuse of discretion. And I make the argument in my brief as to why I think even at that standard of review, it fails. I think in terms of the question that you asked regarding the span of time, first of all, it's actually really not 4 hours, it's closer to 2. You get a text message from Brandon Pavlakis to her at about, I think, 9:30 saying, "What's this that I see in my Snapchat from last night?" And then she doesn't respond to him until almost 12:15. And that's when you get the naked guys and lols and you know, laughy face emojis. And then there is about a 1, maybe 1.5 hour gap between that and when she makes the actual complaint. Now, I would say that there is certainly a lacuna in there, but this isn't, again, as I said earlier, a situation where you're having a face-to-face conversation. It's being done over text messages. I think you have to allow some leeway for the medium, but this wasn't something where if you looked at the full body of the text messages that there is her describing the party and then them talking about something completely unrelated, the Patriots game the night before, and then going back, like everything draws from and is sort of but for what happened the night before. The text from 11:48 until 2 o'clock when she's finished making things, they're just discussing the evening of the 23rd into the morning of the 24th, what happened, her first version of it, then the consequences that she's expecting to suffer as a matter of it because she hasn't called her boss and she slept through her shift and the boss is upset with her. And then she makes the allegation. There's no real strong deviation away from the initial inquiry of what happened last night to when they get to the raid. So I would say that's how you can keep it all together and cabined into a single conversation. Certainly it's part of the same conversation. And with regards to the contextualizing it, I really do think, and I go into that in my brief, I don't want to waste too much more time on it, that it's, if you take that out, if you give the Commonwealth, or not the Commonwealth, the jury what they saw, all they get is her making an immediate complaint of rape, you miss the fact that there's 2 hours of her having a very different take on this beforehand. And it really does change the complexion of things importantly, and in a way that where, again, you had juror questions saying, do we actually have to believe witness testimony? That they don't name her specifically, but they're definitely talking about the rape based on the timing. Excluding that actually, I argue, violates what the doctrine of completeness is supposed to avoid. It allowed the jury to receive a fragmentary to the point of being misleading.
What if, though, instead of a text message, it was verbal? She said the things that are in the excluded text to him by phone. There was 2 hours that went by. There was a subsequent phone conversation, and she made the disclosures. Is your argument the same? Does it matter what the medium was?
That's an interesting question. I would say if it was a phone conversation, yes, because there's sort of more of a demarcation from hanging up the phone and then calling a person back. I suppose if it was I hang up the phone, I call him back 10 minutes later, and it's like, hey, I remembered what I was thinking about. Then maybe you can align the two together. When it gets an hour and a half between the two, it's perhaps a little different. But I do think when, at least in the way that I text with friends and so forth, if I follow something up an hour later, I don't consider that as necessarily, unless I'm changing the topic, I don't consider it as.
Okay, counsel, your time is almost up.
Yes.
I want to turn very quickly to the third issue. It's clear there was evidence that your client, or at least evidence by which a jury could have concluded that your client had misled the police, which led to a frolic and detour. You make the point that it has to be material. What does material mean in this context?
Material in this context, I believe, means that it was something that would have pushed the investigation off onto a track that it would not have otherwise gone onto. And that doesn't happen here. You don't have David Condon giving the police an alibi that is incorrect, that they have to then go run down. He doesn't name a third-party culprit that they would then have to go exclude. He just basically denies it. I think that goes to him.
Well, how about the
address, which I think is what you're asking about here. Yes. It's a little closer to, I think, misleading, but nonetheless, I still think it fails. First of all, because it was absolutely made up. It was something that they could easily exclude, and did so by immediately going and checking it out on Google. It was. It's not clear that it was important to the investigation itself. In fact, the detective, when he was asking Mr. Condon about it, said, we're just doing this to update our records. If they're asking about his whereabouts and he lies about it, that might be a little different. You can see why they might want to know that, but his actual physical address is different from his whereabouts. And really the drive that they took to confirm whether or not this was the correct address or a made up address, I would almost argue goes to them actually trying to support the misleading charge rather than trying to investigate something from the rape. I think they went out to do that.
Counsel, unless my colleagues have any further questions, I think we're going to have to leave it there.
And I'll rest on the second issue. But thank you very much.
Thank you. We'll hear from the Commonwealth.
I just want to let the court know, if I could, I am having trouble with this computer as well. It's freezing and the audio is garbled. I was unable to catch all of Mr. Haynes. I think I got the gist of most of it. And Justice Blake and Milky, I apologize. But so if you'll bear with me, if I'm not responding or if I'm having trouble, I'll try to signal that I'm having trouble. So if it pleases the court, thank you. May I proceed?
Yes, of course.
Okay. Good morning. If it pleases the court, Laura Marchard for the Commonwealth. I am going to try to follow up. Justice Milky, you asked questions about the partying and the heavy drinking, and I would suggest and direct the court, if I could, that the victim was thoroughly cross-examined on this point, on this very issue. So the jury and the evidence that defense was concerned about was in fact amply addressed and thoroughly explored. There was considerable evidence to her what she drank, when she drank it, her going into the bathroom, Mr. Condon following her in, her vomiting, and then she described in the text message that I refer to as the first complaint text message. She texts, and I'm at volume 3, page 60, if I might. I got raped last night. I don't remember what happened after that. I just remember having sex there, and I was saying stop and no. Now, in the second text message that defendant saying was incorrectly not allowed by the trial judge, she talks about her work situation and the playing cards. And the trial judge held that that content was beyond the scope of the first complaint, which then leads me to the adjutant case, 443 Massachusetts 628, where the court, the SJC, states the trial judge is given great latitude and discretion to determine what is probative and what is unfairly prejudicial. And then I know defendant relies considerably on the parent case, but I would distinguish that case from the case now before the court. Because in the parent case, the victim's description from her trial testimony to that which she provided Detective Chalk, and I'm not sure I'm saying his name properly, was different. And the court, the SJC, held that because her substantive testimony about the sex assault
Okay,
was
counsel,
different from what she told to testify at trial, that should have been properly explored. That is what the SJC said was materially inconsistent and should have been.
Okay, but why? I'd like to drill down on that, because
just so you know, Justice Milky, I'm now getting a message saying my internet connection is unstable. Can you hear me?
we can hear you, but it was a little garbled, but I think we got, as you put it, the gist of your parent.
Should I try to? I'm
Um,
sorry, Justice Blake.
I'm wondering if we should have you call in because it's breaking up a lot.
You can keep your video open, but mute your computer and then talk over a phone.
Yes, I have a phone right here. So
That
can you
might
give
be
me
better.
Okay. Bear
Okay.
with me if you could, just a
Yeah.
minute.
if we're gonna freeze the clock at 12 minutes.
Okay, thank you. They want you to stay on the video.
Make sure you mute the computer then, so we don't have echo.
Okay, I'm going to do that now, Justice Milky, if I may.
You probably know this, but you should be calling the New York number on the invitation.
She's muted herself, so.
Understood.
We're still live.
I called in and I'm on hold.
We need the clerk to let you in.
Okay, try it now.
Can you hear me? Testing?
Yeah, except we're getting a feedback. Is there,
You need to-
yeah, your
you
mic
need
is,
to mute-
let's hold
May I
until,
proceed, Justice Milky?
Not yet.
Not yet, okay.
We're live again.
okay, we are back on the record after a little technical problem. I was asking a question actually when we stopped. The Commonwealth put on a great deal of evidence here of the victim's affect and demeanor. Both of her roommates testified about how distraught she was back at her apartment, and I believe one of the police officers testified to the same effect. So from the Commonwealth's perspective, it would seem that her demeanor was critical evidence since 3 witnesses testified it. Why doesn't the earlier text exchange go directly to that point about what her demeanor was when it shows she is making light of the events of the previous night, even to the point of you using a laughing, crying emoji?
Well, if I could, first of all, I believe there is both direct and cross-examination on that point. Not the emojis, of course, but on what they were doing and her demeanor while they were doing that. But I think your question is asking more about her demeanor, not that night during the partying, if you will, but rather about the next morning. Is that correct?
Yes, and the counsel was deprived of using this as impeachment material. So how do you address that?
Well, I'd suggest that the trial judge, who is in the best position to determine what's within the scope of the first complaint and what's outside of the scope of her.
But counsel, you're missing the fact that the completeness argument is his second argument, at least on appeal. He's arguing that, say the Commonwealth had never introduced the second set of text as first complaint evidence, he's arguing that he still should have been allowed to cross-examine the witness about these earlier texts, having nothing to do with completeness, having nothing to do with first complaint.
Well, I think that that's a hearsay statement, that unless you find a manner in which it is not a hearsay statement, it would not be admissible.
So
let's say.
I'm sorry, I missed that.
How is it hearsay?
Well, she's making an out-of-court statement, and it's not inconsistent with her first complaint. It's not inconsistent with her first complaint, and it's also not doesn't come in under the doctrine of verbal completeness. It doesn't explain, contradict, or put into context the first.
Isn't the fact that she said LOL independently important, regardless of the truth of the matter, whatever the truth of LOL means?
Well, except that they're on an entirely different topic. They're talking about, if I could, they're talking about
The poker.
the poker game and the state of undress or clothing, if you will. And then that's exactly where the LOL comes in, that they were playing cards and that they lost. So that's, I would suggest or argue that is.
Counsel, the point that I think Justice Milky is making is that you've put in 3 witnesses, the Commonwealth put in 3 witnesses about her demeanor, and that it doesn't matter what the content of these earlier text messages are in terms of defense counsel was not offering them for the truth of strip poker. They were offering them for her demeanor and for her, that she didn't seem upset, when the Commonwealth has made a point of proving that she was upset.
But I think both through her direct and her cross-exam, her fluctuating demeanor, or her demeanor that at times is jovial and at times is extremely distraught, is thoroughly explored.
Not in the hours later. We're not talking about her demeanor during the game of strip poker or sending the Snapchats. We're talking about the next morning at 11:45, when she's back at home writing to her best friend and sending LOL messages and laughing emojis and such. I mean, the whole point that the defendant is making now is he was deprived of being able to raise this stuff.
And if the court should find that that is a material area that should have been admitted, I'd suggest that the evidence here was overwhelming and that the court ought to consider and weigh that.
How can the evidence ever be overwhelming when it's all about credibility?
Well, the courts have said, both in the parent case and there was in the Edgerton case, that it's the trial judges in the best position to make a determination of what's probative and what's prejudicial, what's material and consistent, material with what would be a material area, if you will, that should have been explored. And that I would defer back to that.
Okay, counsel, say it hadn't just been LOL, but it had been more text, in the sense of responding to her best friend saying, yeah, I had a great time last night. Same answer?
I appreciate the court's hypothetical. I think the closer you come to the actual sex assault or the rape, as opposed to the topic that they're actually talking about, which is playing cards at the time, that is the context. We were playing cards and they lost. Mr. Pavlakis asks, where was that and who TF was that? And she said LOL. So I think this is distinguished because it's a separate subject matter. I would, in response to your question, note that if the closer you got to the actual sex assault, the same subject matter of the first complaint where she announces that she was raped, then the answer may mold or change accordingly.
Is it different, like I asked Mr. Haynes, if this all transpired over a phone call and not in writing through text messages?
I think it would be a more clear issue and less suspect or less open to challenge by defendant if it was a separate phone conversation. Because it's a text message that melds one page into the next, and you have to actually check the time to see how much time has gone by. I think with a phone conversation, which I believe was addressed by the court and Mr. Haynes, it would be less open to argument by the appellant, by the defendant.
Why? Because I can imagine the equivalent phone conversation. Oh yeah, it was really funny. We were so wasted, and I got the better of them. They lost, and I sent the Snapchat of those naked guys. It was hysterical.
Well, I think if you have a different subject matter, then you have to look to the discretion of the trial judge and see if the decision to find it a separate subject matter was reasonable, which in this case Judge Rufo did.
Does the 2 hours make the difference here or not?
I think the time contributes to the analysis that it's a separate conversation, a separate topic.
So if she had had the same time frame and exchanged texts with him that had nothing to do with what happened the night before, but they certainly didn't show her as being upset or despondent or anything else. She was talking about, you know, some other thing that happened. 2 hours go by, and then she sends a text that says, "I was raped last night." Does that change the analysis? Is it that the substance of the text messages that is really at issue here?
I think it's a totality of the circumstances. You have the time, you have a different subject matter, you have several different subject matters, actually. So in the first text message, they're talking about the naked game of cards, and they're talking about her work situation. When she makes the first complaint to Mr. Pavlakis at 1:48 p.m., you have a significant amount of time that's gone by, and you have an entirely different subject matter. And I say this argumentatively or hypothetically, where do you draw the line if you have text messages? These two are making text or they're text messaging apparently frequently. So if she has a jovial and conversational manner, I just would suggest the child judge was not inappropriate in finding.
Isn't there a difference, you know, had she been talking about the Red Sox, that's a different subject matter, but she's talking about her feelings about what occurred hours before, and it's kind of, you know, as I suggested earlier, one can certainly view the drinking as being intimately tied to the allegations of rape here.
You certainly can make that argument. It would be a case that if it was a red topic was a sporting event as opposed to an event that she herself was participating in, that is the card game, then it would certainly be an easier call.
Okay, can we?
But I don't think it changes, with all due respect, I don't think it changes the end result. I think the judge is not in a...
Counsel, time is of the essence. I want to just briefly get into the third issue. At trial, the Commonwealth seems to have been at least suggesting that there are lots of ways that the defendant misled the police, including denying that he'd ever been to this, that he knew the actors, etc. On appeal, one can read your brief as suggesting you're falling back solely on the address issue. Is that a fair reading?
With all due respect, no. I don't think we abandon the fact. Clearly, the most egregious, if you will, or the starkest, is the fact that he didn't just appear to have, the evidence didn't substantiate the defendant simply having the intent to mislead them. He physically misled them. He sent them to an address. The Detective Ulrich testified. They went to an address that doesn't even exist.
Well,
so,
to be fair, I'm not sure he sent them anywhere.
Okay, fair enough.
They had 3 addresses already. They were trying to find the guy. They reached him by phone, tell him that they're trying to just update their records, and he gives them a false address. How did that turn the sort of substance of this investigation? There was never a question of identity here. There was never a question of someone else. It's whether or not this was consensual or not. So they deciding to go look for him spent some more time on this. How is that materially misleading the investigation?
So my answer is twofold, if I could. If you look at volume 4, pages 16 and 17, the police talk about, as over a week later, that they had still not been able to locate David Condon. And despite repeated efforts and fairly creative investigation, they sought an arrest warrant. And they only did that when their efforts to locate him were exhausted. And if I could, and I know I'm over, the time has expired, but if you could indulge me just a moment, the two cases, the Tejito case and the Morse case, are so strongly, we can distinguish those cases. In Tejito, it's nonverbal conduct, and SJC said there was no attempt to create a false impression or deception. That's not the situation here. Similarly, in the Morse case, the defendant denied his drug consumption, and the court held that there was not willful misleading a police investigation because there was no evidence of, quote, an affirmative misdirection. We have that here. We have an affirmative misdirection. We have, going back to—
Counsel, we're gonna have to leave it there. We understand what you're arguing. Thank you both very much. The case is submitted.
Thank you for your patience.
We are live.
Thank you very much. We are back on the record for our second case. This is Commonwealth versus a juvenile, 2019 P 1645. And I just want to caution the parties that please do not use the names of the juvenile. And
I think Ms. Gellison has an issue. Hold on.
I think we have a dog issue.
I am terribly sorry.
Don't worry.
I'm sure she'll calm down.
No problem. I think most of us on this call have dogs. So, I'm.
Hold on.
My apologies.
Understood. Not a problem. If you are prepared to go forward,
Absolutely.
The floor is now yours.
Good morning, justices, and may it please the court. I represent the juvenile, and this is a one-issue appeal, whether Officer Lopes had reasonable suspicion to believe that the juvenile had or was committing a crime when he grabbed her arms.
Can I ask you three just preliminary questions to get them
Absolutely.
out of the way? I understand that the Commonwealth is agreeing that the possession of ammunition charge is duplicative, so that you all agree will be vacated. The Commonwealth also says that your appeal did not cover your client's statements, that they're not subject to the appeal. So do you agree with that?
I don't agree with that because anything flowing from the illegal stop would be suppressed, so the statements would be part of that.
Okay. And do you agree that, at least as before Judge Johnstone, social science evidence was not presented to him in connection with the arguments made?
Social science evidence was not presented to the lower court, but I will note that in several opinions, the SJC has relied on social science that was not presented to the lower court.
No question. I just want to make sure we know what was happening.
That is the record.
Below.
That is the
so
record.
I interrupted you. I'm sorry. Go ahead.
No, so I was just going to start with kind of the facts that we're dealing with in totality. And I just wanted to review them because they're so important. So we had two juveniles walking along Heath Street. The juveniles seemed to notice a group of 7 police officers, and Officer Lopes is observing this from his vehicle. They turn right, which he described as broke right, into the complex, and he observes the juvenile looking over her shoulder multiple times and adjusting her waistband. He then exits his vehicle. He follows the juvenile. They get to a point where the juvenile takes a left turn. He can't see her. When he reaches the point at which she has taken the left turn, he sees her coming back toward him. She tries to walk around him. He grabs her arms. That's definitely the moment of seizure. So
no one disagrees with that, right?
No. And those are the facts that we have leading up to the seizure.
So you're not arguing that the seizure took place before that?
I'm not arguing that the seizure took place before that. So I want to focus on the totality first, and I want to point the court to two cases, which I did in my brief, Commonwealth versus Wright and Commonwealth versus.
I want to, before we do that, the judge made a specific finding that she made, quote, several more adjustments to her waistband in this period, okay? And I'm trying to understand if you are challenging that or if you are not challenging that.
I understood the testimony and the finding to mean that as she's walking away and as Lopes is observing her initially, that she's looking over her shoulder and adjusting the waistband at the same time. And that could have been several adjustments of the waistband. But I believe that those are the facts. I don't believe that Officer Lopes said that she continued to do that behavior once he had gotten out of his cruiser and followed her. And I didn't see the court's findings as saying that either.
So I guess what I want to understand is, are you thinking that there was one confined period where she was touching her waistband, or was there, do you take this finding to mean there were multiple times when she was touching her waistband?
I took it to be one period of touching her waistband as she's looking at the police officers while Officer Lopes is observing her. And that's consistent with the transcript. That's how the testimony came out as well. So that's how I took the findings. And, you know, to the extent that the judge found that she continued to touch her waistband while Officer Lopes was following her, I don't believe that the record supports that. So that would be clear error. But I'll have to say that I did take it as there was a period of time that she was looking back at the officers and adjusting the waistband.
And I think what's hard is that the actual, on page 2 of his decision, he says, as the juvenile was walking, comma, she continuously looked over her shoulder and adjusted her waistband. So we really don't know what the continuously relates to, although it sounds like you're not contesting that she looked over her shoulder multiple times.
Absolutely not. Officer Lopes said she looked over her shoulder multiple times and adjusted the waistband. And he even demonstrated by looking over his shoulder, adjusting the waistband. So I think it's relatively clear that that was the testimony and must have been what the judge found.
And you were going to tell us two cases. One you said was Wright. What was the second case?
The second is DePisa, and that's an SJC case. And I think that one's particularly helpful because it went the other way. It was described as a close case. And I would say that the facts until the moment that the SJC said that the most significant fact happened were very similar to this. So I'll just read from the case. So in an area with, quote, increasing incidences of firearm violence, the defendant was, quote, walking with his right arm stiff, and the defendant became nervous and hid his right side from view upon encountering officers. But those details were insufficient. And that's very similar to this. We have an area where there are firearms incidents happening. The juvenile exhibits some nervous behavior. She isn't walking with the right arm stiff, but she adjusts the waistband. And the SJC needed more. And what they needed was that officers finally glimpsed the defendant's right side and noticed that the right jacket pocket appeared to hold a heavy object. So I would say that if Officer Lopes gets out of his cruiser, he walks up to the juvenile and he sees some sort of heavy object, we would be in a different world.
Well, except that, and I know you talked about this a lot in your brief, so I actually went through the transcript to see how many times the word blade, blading, or bladed was used, and
Absolutely.
It's multiple. And there was definitely, I would say, some great cross-examination on that question, but ultimately on redirect, the officer says that she was blading to the side. So don't we have to, I mean, that's what, that was the last word on that. And I know in your brief, you say that we can't consider that, or it was at least unclear, but I think that's part of the totality question, isn't it?
I'm saying something a little different, if I might clarify.
Okay.
So what I'm saying is that he didn't testify the juvenile bladed and she looked over her shoulder and touched her waistband. What he testified was that he considered looking over the shoulder and touching the waistband to be bladed. So what I was trying to clarify is not that he said blading, absolutely. And so he said it in response to cross. So yeah, 2 things, not 3. Okay. Touching the waistband, looking over the shoulder. If that's blading, it's blading. I'm not an officer, but that's what happened.
But it was also turning away, wasn't it? Isn't that part of blading?
Let me just look to exactly what he said. One moment, please. So this is what he said. If she's holding the waist and turning, that's bleeding. So I believe what she did was adjust the pants and turn, and that's it. And he called it bleeding on cross-examination, but it was one, or, you know, I think we talked about this, perhaps a continuous set of behavior during that time that he was observing her from the vehicle. But that was the behavior. And I think, you know, what Justice Lowy said during the Evelyn argument was very helpful. You can term something, you know, you can term something bleeding, but let's just say what it was. And the officer said, if she's holding the waist and turning, that's bleeding. And, you know, he clarifies, you know, she turns to the left side and looks back at the officers several times. She's adjusting the waistband.
Your point is that it's a loaded characterization of what she was doing as opposed to a description of what she was doing.
I mean, I think that that's true, but my point is a little bit different in just that I want to focus. I think what the judge ended up finding was that she was holding the waistband and turning and blading. And I think the proper finding should have been she was holding the waistband and turning, which the officer termed blading. So just that there was not a separate act of blading from what we're talking about with turning and adjusting the waistband. So to go back, although this is a totality of the circumstances.
So it seems to me that this particular officer is not using this word the way other officers use this word.
It did not seem that he was.
Okay.
And since he clarified, I would say we should go with what he said. So
can I ask you on the social
absolutely.
science piece? There's something in your brief that says your client could have been mistaken as a boy. Those are my words, not yours. You said it much better than I did. What is there in the record that supports that?
Yeah, so even when the officer testified, he repeatedly referred to the juvenile by the he pronoun. And that is what I'm saying supports that finding, or that.
There's
that
no
argument.
photo of your client in the record, right?
I do not believe there's a photo of my client in the record. But even as he's on the stand looking at my client, he's referring to my client by the he pronoun.
And
so I
we
would say
don't
that
know if your client said those were your client's express pronouns.
I do not know. Well, I don't, you know, I'll have to say my client and I didn't discuss pronouns specifically. But someone perceived, I mean, I would say someone perceived repeatedly, even when they're in front of the officer on the stand, as a young man, perhaps looks like a young man to other people. So I think I'd just like to come back to the fact that even though this is a totality of the circumstances analysis, and I think that DePisa and Wright are very helpful, the case law has changed since those cases were decided, and in a way that favors my client substantially. So the most recent case from the SJC, Commonwealth versus Evelyn, counsels us that we need to take both evasive and nervous behavior around the police and give it very little weight in the reasonable suspicion analysis. So that applies to this case because the allegation was that my client walked away from officers twice. That's evasive behavior. Because of Evelyn, it should have very little weight in the analysis. And I think you could also see.
We have to get into the race or age of the juvenile. I mean, I think any person who saw 7 police officers might think it's a good idea to walk in a different direction, even if they were entirely not doing anything wrong. Nothing good is going to happen at a point when 7 police officers are walking into any situation, but here we have a housing project.
Yes, and I agree. I think that a defendant of any description would have done the things that my client did if they wanted to lawfully not encounter police officers, which they have the right to do. And I think Warren has some nice language on that. We all have the right to avoid encounters with police officers. I think all the race aspect does here is to perhaps give even less weight to the fact that this person avoided police officers in the city of Boston. And I include some statistics showing that the statistics that the court relied on in Warren were also present in 2018 based on the Boston Police FIO statistics. So would there be reasonable suspicion to stop anyone who was doing the innocent activity of walking away from police officers and looking back at them? No, there wouldn't. But especially in this situation, I think we have to give it even less weight given the court's rulings in Warren and Evelyn.
But here's at least as I understand it, and please correct me if you disagree with me, the constellation of facts that this judge relied on to say that there was reasonable suspicion were repeated and evasive movements of your client, a change in direction, quote, constant looking back, blading, we've talked about that, continuous adjustment of the waistband, and known firearm activity.
Yes.
So those are, you don't disagree that that's what he said and that those are supported by the record. It's your view, however, that that constellation of facts does not equal reasonable suspicion.
That's correct. And I think that what the analysis is that you have to look at the weight of each of those factors and then put them together. And Evelyn tells us that nervous and evasive behavior should have very little weight. Evelyn also tells us that firearms incidents in the area have to be directly connected to the area and to the specific incident, to the juvenile. There was no suggestion that the police had any information about this juvenile or her activity, and there was no specific information about the firearms incidences that they were talking about. So I think Evelyn would counsel that there should, yes?
Just in fact, there was no evidence whatsoever about the reliability of the tipster who called 3 hours earlier, correct?
Absolutely. There was no evidence about what she saw other than a group of children. And I believe if you look at Commonwealth versus Manuis, a group of young Black males is not a sufficient description to create any individualized suspicion on a particular person. So a group of juveniles, in particular 3 hours prior, is certainly not enough under Manuis from the SJC. So
and Evelyn talks about the juvenile's age. Do we have anything in the record about what the officers knew about your client's age before the stop?
I believe that Officer Lopes believed her to be a juvenile, but I don't believe that there's
nothing more than, okay,
further information about that. And on that point, Evelyn does say that age is relevant to whether or not the juvenile was seized at the moment. So it would certainly bear upon my arguments, but it doesn't control, and I don't need it. I mean, this case would be,
in fact, the two of you agree on when she was seized.
Excuse me?
The two of you agree on when she was seized.
We do. So there's Evelyn is more helpful on the point of nervous and evasive behavior carrying little weight in the reasonable suspicion analysis. So just to conclude, and of course I would answer further questions from Justice Blake's.
Yes. I do have a further question. Why don't you conclude?
To go to Justice Blake's question, I agree that those were the factors that the judge considered. He didn't even consider Warren, and now we have Evelyn. The analysis is different. This court should do that analysis de novo and apply the appropriate weight to each factor. And I would just point you to the cases that I cite in my principal brief as to adjusting the waistband and what weight that should have when it is one of the only factors that you're looking at. Yes, Justice Henry?
So what I hear what you seem to agree to Judge Blake and the constellation, but this is where I'm confused and where the findings are confusing, because on page 2, the court writes in the middle of the first full paragraph that as the juvenile was walking, she continuously looked over her shoulder and adjusted her waistband.
Right.
And that seemed like the word continuously goes to waistband, which means we have multiple touchings of the waistband. Whereas on 2 pages later, what I asked you about earlier on page 4 was, it says adjusted her waistband upon first encountering police. And that's one touching of the waistband. So
I would point the court to the transcript where I believe it is clear that she could have certainly adjusted the waistband more than once as Officer Lopes watches her walk away from the police officers, look over the shoulder and adjust the waistband. I don't believe that the transcript would allow a finding that she continued to adjust the waistband when she was not looking at the police officers. I believe those facts are tied. So to the extent that the judge's findings are confusing, this court could find that they mean what the transcript says, or that they are clear error in light of a transcript that clearly ties the facts of touching the waistband and looking over her shoulder together. And what if that was continuous for a period of time, or she did it several times in that first moment while Officer Lopes is observing her, then I would agree with that. And just one other point on that. In Jones-Pennell, there was that there was a flight from the police while the defendant was holding his hands inside his pants during the flight, and that was insufficient. So to the extent that there's some continuous action, that case would be instructive.
Do either of my colleagues have any further questions?
Thank you very much.
Thank you very much, counsel. We will hear from the Commonwealth.
Good morning, and may it please the court, Catherine Sherman on behalf of the Commonwealth, asking
Can I
this
ask you
court.
just a couple of preliminary things to get them out of the way?
Yes,
You agree that the ammunition adjudication should be vacated?
that's correct.
After hearing Attorney Jellison's view on the statements, do you still contend that they're not subject to this appeal?
I do.
As fruits, that they're
As-
not?
They would be as fruits. They are not argued separately.
And do you agree that there's nothing in the record about the juvenile's appearance, that she may look like a boy?
There is nothing specific in the record to that. I agree with counsel that she's referred to by a he pronoun, and upon the stop makes the point that she's a female, so they
Okay.
call a female officer, but there is nothing specific in the record about how the officer perceived her gender.
Thank you.
And I'd like to,
That she felt the need to announce it to the officer in the heat of the moment.
yes, I think that indicates her knowledge and desire to have the frisk performed by a female rather than a male.
And that they may have perceived her as male.
That maybe
Enough
though,
so that she felt the need to tell them.
perhaps, or just her preference that it be a female that do the frisk rather than a male. I'd also like to clarify some of the questions that had been made about the record in terms of the adjustments to the waistband, the looking over her shoulder, and the blading of her body. And those are three separate behaviors that she exhibits. And beginning with the grabbing of the waistband, it is in the record that she grabbed the waistband multiple times.
Where is
Looking at
that?
transcript page 32, the officer is answering a question about what observations he made. And in describing the juvenile, he says, this is the same individual that we observed making all the adjustments before we exited the vehicle. I think that in conjunction with the rest of his testimony about his observations makes clear that there was more than one adjustment made to her waistband.
Well, this is what
Similarly,
I don't understand, and what we're really trying to drill down on is, was there one episode where she's touching her waistband, or were there separate episodes where she's touching her waistband? And it's your burden of proof, so can we tell?
And by that, do you mean, so I think her path of walking is at least understandably differentiated between the turns that she makes. And it's clear that she adjusts her waistband after she makes her first turn. I think it's implicit in the record, and I think the judge did too from his findings, that she's adjusting her waistband throughout the entire observations that the officer makes, which involves her walk into the development and her two turns before coming face to face with Officer Lopes. I'd also like to point to the distinction between her looking over her shoulder and her blading her body. On transcript page 58.
Let's pause here and say that the Supreme Judicial Court has said this term is not helpful. And I can assure you that I agree that it is not helpful when the police give this testimony.
It's not helpful as a conclusory term. However, this officer got off the stand and demonstrated and described what he meant by blading multiple times in the course of the hearing, including on transcript page 58. When he says that it's her turning her, I'll read the exact quote. As she's walking, she turns to her left side and looking back at the officer several times, back and forth while she's walking on that pathway before taking a left turn. So he's clarifying that the blading of her body is the physical pivot of her body away from the officers, which is distinct from her looking over her shoulder.
Because this is what I find confusing, because And I'd be happy to have you demonstrate it now, but I don't know any human being who can turn around and look at a person without turning their body.
And I think the importance of that action is in the context of everything else she's doing. She's not just pivoting her body and looking over her shoulder. She's continuously looking over her shoulder, turning her body multiple times, continuously grabbing her waistband, and in multiple times, changing direction abruptly on her path through the development. Equally important is the fact that this is all viewed through the lens.
A citizen who has not committed a crime, who sees 7 police officers walking towards a situation, would you think that it is advisable to continue yourself walking towards that situation?
I don't have a personal opinion, but I think seen through the lens of an experienced officer who's noticing the physical movements and gestures that to him, based on his experience and training, indicate she's carrying a concealed weapon, that colors the lens through which he's observing her behaviors. I don't think...
Counsel, on DePisa,
yes.
You've heard your sister's interpretation of that what really put this over the top in DePisa and was essential to the court's ruling was the direct observation of a heavy object in the pocket. Why isn't that a reasonable interpretation of DePisa?
I believe in DePisa, and I apologize for not being able to recall all of the facts off the top of my head, but DePisa doesn't rise and fall on the observation of an object. DePisa's holding and conclusion was more about what the officer saw and how in the totality that led to reasonable suspicion. And included in that were the physical mannerisms of the person who appeared to be carrying a concealed weapon. If I remember correctly, the officer in DePisa was less experienced than the officer in this case and did not have, as articulated in the case, if I remember correctly, the experience and training that this officer had on people who carry concealed weapons and the significance of that.
So I just, to Judge Henry's point, I do note in the record that it's defense counsel that first used the word blading, and then that had to be cleaned up on redirect because the Commonwealth had not used that word. But putting that aside, is Sykes your strongest case?
I think Sykes is a strong case. I think DePisa is a strong case for the Commonwealth.
But I feel like in DePisa, you have what we have here, and I think Attorney Jellison agreed with me. We have this constellation of facts, but you had a plus, and the plus in DePisa, as Justice Milkey just pointed out, was the heavy object. We don't have a plus here.
This case is different. However, the multiple adjustments that she's making to her waistband are described by the officer as a secure check. And he describes that in the context of something being hidden and being held that somebody wants to make sure is in place as they're moving.
The judge used the expression secure check, but did the officer use that expression?
You're correct. The officer does, the judge does use it in his findings. I don't recall if that's what the officer describes it as.
Well, on page 16 of the transcript, the officer defines the expression secure check, but the officer never, unless you can show me a record site, the officer never actually says the juvenile did a secure check.
Right.
Well, isn't that true in any event like blading, in that it's a characterization of actions rather than a description of the actions themselves?
Yes, and and him using that term on page 16 is in the context of describing somebody carrying an illegal firearm in a waistband.
Without a holster, yeah.
Yes, rather than a holster.
So what about the social science arguments that your sister makes? Can we consider those?
No, they weren't presented to the judge. And most importantly, the race of this juvenile is not in the record. This judge was not presented with evidence related to the race of the juvenile, and he has no responsibility to sua sponte, make findings and make decisions based on that. The social science was not presented to him, and this case was not argued as a racially motivated or improperly motivated stop.
Okay, counsel, I'm going to ask you a very strange question, which is, why can the second floor consider the social science research, but we can't?
The second floor meaning the SJC.
And I believe in those cases before the SJC, race is already present in the record before the court. That was something argued in the lower proceedings and presented to those lower courts. So it was incorporated into the judge's findings and the record that they were relying on.
Well, when you say that that race is not in the record, the judge's ability to perceive the defendant, even though we don't have a picture, was part of the judge's record, correct?
To that point, I'd argue that the race of the juvenile may not have been entirely clear to the judge. And what was important is the officer's observations of the race of the defendant in the context of the juvenile in the context of this stop. The judge is not required to make that finding sua sponte, nor should he. And clearly his findings in this case were made entirely separate and entirely apart from the race of the juvenile. Regardless of her race, his basis for the findings of facts and his rulings of law are supported by the record and are not in error.
So I want to understand the limits of your position here. So let's leave race out of it for a minute. You have a citizen, maybe they're a juvenile, walking, and they see 7 police officers, and they, for whatever reason, touch their waist, make one set of adjustments, not multiple adjustments, just one set of adjustments, and turn away from the police. At that point, is there reasonable suspicion to stop and search them?
I would suggest no, but I would suggest that that's far less than what's present here. In this case, it's not that she is making any one of these observations once. It is continuous, it is multiple, including her abrupt pivots, her abandonment of her companion to change direction. And it's all taking place through the lens of this experienced officer. That hypothetical is hard for me to answer because it is such a minimization of what's present here.
You say that the defendant misunderstands or misapplies Warren. Could you speak to that?
Well, I think there is a distinction between what happens here and what happens in Warren in terms of the police-initiated contact. The nuances that Warren adds to how race should be perceived in the context of a stop is in terms of like a police-initiated stop and somebody's response to that stop, or police-initiated contact, not stop in the legal sense, and somebody's response to that, how that shouldn't be considered as part of their reasonable suspicion analysis. In this case, the officer who is seeing the juvenile's avoidance of officers, her inexplicable turns and changes of direction, which are distinctly odd behavior, combined with all of the movements that I have made clear, that's a very different scenario than him initiating contact and her reaction to that contact being part of the reasonable suspicion analysis. He's observing this from a distance, and from a distance, without trying to initiate contact with her, he's watching her avoid contact and proximity to police. And combined with her avoidance of that proximity, with the grabbing her waistband, looking over her shoulder, changing direction yet again, that in totality gives him reasonable suspicion. It's not her avoidance of police that tips it into the realm of reasonable suspicion.
Okay, can the phone call from the anonymous tipster 3 hours before play any appreciable role where there's been no evidence of the reliability of the caller?
I think that tip really falls into the same weight that should be given to a high crime area. I think that tip really falls into the same category as the fact that shots were fired the day before, that there were prior recent firearm incidents in the area. I'd categorize it as more of a high crime area coloring of the officer's observations.
Judge Johnstone did not have the benefit of the Evelyn case when he wrote his decision. Does Evelyn change the result here?
No. Evelyn's findings, the observations in Evelyn that the court affirms lead to reasonable suspicion are similar to this case. The physical movements and observations made of the juvenile that indicate he's carrying a concealed weapon. Evelyn does not change the finding here.
Okay. Do either of my colleagues have any more questions? Hearing none, well,
We are live.
thank you very much. We are back on the record with our third case of the morning, Commonwealth versus Resendez, 2020 P87. This is the Commonwealth appeal, so we will first hear from ADA Lee.
Good morning, Mary Lee, Assistant District Attorney from the Bristol District for the Commonwealth. This is a Commonwealth's appeal, as has already been noted. This case was dismissed on the complaint in the district court, and the Commonwealth has appealed. The primary issue is whether there was sufficient information to show probable cause that there was a public way for an OUI case. So we look at the four corners of the complaint application, and we look at it in the light most favorable to the Commonwealth under Commonwealth.
And that includes the police report, right?
Yes. And so that's Commonwealth versus Santos is the citation for that. And the standard for probable cause is reasonably trustworthy information to warrant a reasonable person in believing that the defendant committed the offense. So in this case, as the court knows, the defendant was found basically unconscious, not able to be roused, parked in a running car that was in a driveway. It was blocking the person who claimed to be the resident of that address on Hathaway Street in New Bedford. They could not get their car out. They could not rouse the defendant, so they called the police. The car was also blocking the sidewalk. The police came to Hathaway Street, tried the similar materials, had to open the door in order to rouse the defendant. He appeared to be impaired, and he had what appeared to be heroin in his possession. Just for note, the possession of heroin charge was dismissed because of the Good Samaritan law. So
A sidewalk is not a public way, right?
right.
But
And
for purposes of probable cause, is it fair to say that the only way he can get into that driveway is driving on Hathaway, which is a public way?
that's the reasonable inference from this police report. I acknowledge that it doesn't say that precisely, and we rely on the Bellevue case. Now, there's two cases that the judge relied on and that are in both briefs, Virgilio or Virgilio, I apologize for not knowing how to pronounce that, and Bellevue. I also hope I'm pronouncing that correctly. The Virgilio case says driveways, private ways, private parking lots are not public ways, and the judge relied on that. I would point to footnote 3 in Virgilio. In that case, you could not draw the reasonable inference that the defendant, Virgilio, had driven drunk on a public way because she had come out of her home, or a home that was connected to that parking lot, got in her car and began to drive and did not ever make it to the public street. So I agree, if there's evidence that this person has not driven drunk on the public way under Virgilio, which was a required finding standard, not a probable cause standard, then the judge would be right.
Because in
Bellevue,
Virgilio, the argument was that she was drinking in the house and then came out to the car, so the drinking happened before the driving?
yes, and she never made it to the,
If this was if it was for some reason clear the defendant lived either in that house or maybe this was a shared driveway and he was just found in the motor vehicle then you would agree this would be properly dismissed?
Right. If I'm sitting in my house drinking and I walk out to my driveway and sit in my driveway and turn on my car, then I can't be charged with OUI, which is essentially Virgilio. But we look at the complaint application in the light most favorable to the Commonwealth. We don't look for the Commonwealth to exclude all possible innocent explanations. That's not the standard. And
So
in
the
Virginia,
defendant here has given us two, I don't know if I'll call them innocent explanations, but non-public way explanations. And you're just saying we should disregard those based on the standard at this stage of the case.
right, because we take it in the light most favorable to the Commonwealth, and the defendant can raise those at trial. We have not even gotten to trial like in Bellevue and Virgilio. We're on the papers written by a police officer. And so I would suggest that the standard is what distinguishes us from Virgilio, as well as those facts that are in footnote 3 of Virgilio. Then we look to Bellevue, and so I'm going to acknowledge that we're not on all fours with Bellevue, which the judge ruled on, because Bellevue has the timing of it. Bellevue drove on a pier that was open to foot traffic and open to private vehicular traffic, but not open to public vehicular traffic, which is important for us because the fact that the defendant is blocking the sidewalk or the driveway where people could walk is not sufficient to find a public way. We have to show that this is something that's open to vehicular traffic. And so in Bellevue, we have someone who sees Bellevue coming down the pier, and it's a reasonable inference he has just gotten off the public way. So it's the timing that the motion judge found distinguish our case from Bellevue. What I suggest distinguishes our case from Bellevue is, again, the standard. Bellevue is a motion for required finding where you get in all the evidence and the statements of the precipient witnesses. Here we are on the papers. It's a probable cause standard. We look at it in the light most favorable to the Commonwealth. And when you look at these facts, it is approximately 2 o'clock in the afternoon. The defendant is the only person in the car. The defendant does not make any statement about someone else driving the car. He said he's there waiting for a girl, which would indicate that he had driven the car. Another reasonable inference that he had driven the car is that it is his wife's car. It's on Hathaway Street in New Bedford, the driveway is. He doesn't know where he is. He doesn't know any of the people in the houses. The person who has called the police doesn't know him. And I would suggest the reasonable inference from these facts is that he was driving intoxicated, pulled into the driveway, and passed out with the car still running. While that is not the only explanation for these facts, it is a reasonable explanation, and it is the explanation that is taken in the light most favorable to the Commonwealth. And that is why the Commonwealth has appealed this. We think that the judge didn't have the facts wrong. He did not view the complaint application in the light most favorable to the Commonwealth or on the correct standard of probable cause.
So
That is
the defense counsel will argue, I'm predicting, that where there are at least two possibilities that involve not operating on a public way, either that the defendant just got in the motor vehicle and consumed drugs there, or that he'd been at a different house in the neighborhood and then consuming the drugs and then got in the car. You know, that they'll argue, well, the jury would just be guessing as between those three ways, and so the case should not proceed. So what's your response to that?
Well, we haven't even gotten to the jury yet, and the defendant was given an opportunity to explain himself, and he said that he had not taken drugs, and he said he didn't know where he was. And then when he began to look around, he was disoriented, but he began to say he thought he was near Expos. So this idea that he came from one of the houses is discounted by his own statements, and as well as his opportunity to explain that he had just become intoxicated in the car. He did not say that either. I have nothing further, but I'm happy to answer any questions that you have. Otherwise, I would rely on the brief for any.
Hearing none, thank you very much. We will hear from the defendant.
Good morning, Sharon Sullivan Puccini for Mr. Resendiz. I'd like to point out specifically the probable cause standard and something in the Commonwealth's brief. And I quote, something definite and substantial, and that's from the Rogers case. for the probable cause. It has to be more than mere speculation. What we have here is speculation that he drove on that public way. The one case cited by the Commonwealth is Bellevue for the proposition that the defendant had to have driven on Hathaway Street before getting to that driveway. One thing I'd like to point out that was argued this morning was that that the caller was a resident of that address. Now, all we have in the narrative is that she said that she had attempted to wake the male and that he was blocking her vehicle in her driveway. However, in the complaint, her address is totally different. It's not 110 Hathaway Road. It's a different address. So there's also speculation that he had to have gotten there on Hathaway Road and he was already intoxicated on drugs. However, as Justice Henry said, he could have been, in one of the houses nearby or in that house. There's no evidence that that was a multifamily, or if it wasn't a multifamily house. There's nothing specifically saying that. Also, it could have been a shared driveway. There's no information in the complaint that it was not a shared driveway. Bellevue had something that this case does not have, and it has an eyewitness, somebody specifically seeing that defendant at the entrance of the pier, and then later on the, right after, get out of the truck.
Why aren't these fact-based arguments more appropriately made to the jury at the trial? At this point, the only question is there probable cause? And these alternative theoretical explanations, the cases are clear. The Commonwealth doesn't have to rule out if it can show probable cause.
But it does have to show probable cause on the complaint, that a complaint should even have issued. They have to have, the police officer has to have enough information in there for the magistrate to have issued the complaint. There has to be specific information. And the cases that we're relying on, Bellevue, and I also cite George, I cite Virgilio, which I'm not sure if I'm saying that right as well. Those weren't.
How many of those are probable cause cases?
Those are not. They're not many. I actually went and looked at 128s. I only cite one 128 in my brief, but I looked at recent 128s that the court has issued, like in the past year. And what's different with those cases, you have an admission. You have an admission that the defendant said, "Oh, I just came from the bar. Oh, I just came from this house. I'm dropping somebody off." Those cases have that. They have like somebody having seen. Here we don't have anything. So it's just as plausible that he had been in the house, used drugs, or drove there and used drugs.
How many of those 128s found the lack of probable cause?
They don't. Wait, I gotta see if they might have been. I don't know if those are probable cause, but they. I'm just looking at them. One of them was an older one was Jackson, which was one of your cases, Justice Milkey.
What did I say?
I don't, and I apologize because I just did this quickly when late yesterday, and I wrote notes. So I don't think they were probable cause cases, so I don't want to say that they were, but I know that there was something more. Like in Bellevue, you have that eyewitness that somebody saw the person driving. And in other cases, one of them is Miranda. That was one of Justice Henry's case from this year. And you have, again, they admitted they had been driving the truck. There's always something else. We're only at the probable cause stage having to do with the complaint. We're not at, required finding, but they have to have something definite and substantial, not piling on of inferences, which we have here. And I think what is important to know is specifically that we don't know if this is a multifamily house. And specifically when the caller says they're blocking my car and the police officers write down her driveway. but it's not even her address. So, who knows? She could have been someone that was just visiting there or dropping something off, or, who knows? And in Bellevue also say it has to be, quote, obviously that the defendant had driven on the pier. It was obvious that he was on the roads before leading to it, and we don't have that here. There's no witness that saw him on Hathaway Road. How long he was in the driveway. There's no information if there's a multifamily residence. There's just not enough, and it's too much speculation. It is the light most favorable to the Commonwealth, but it can't be speculation and piling on of inferences, which we have here.
Record address of the caller that you're saying is different from Hathaway. What record page is that?
Yes, that's in my brief, and it is, I have it right here for you. I have that written in my brief, and it is,
I think it's page 9 of the record.
9. Yeah, I see it 9 at the bottom. I'm just making sure that's a record appendix site. Page 9. It's a totally different address, so there's too much speculation. Now, Commonwealth versus George, which is another case that I cite in my brief, there could be similar to this case, where a woman and her husband drove in Brockton onto a private, I guess it's called, it was not considered a public baseball field, private. They drank beer there, and then they tried to leave, and the husband drove the car and flipped the car over. And there, it was not a public way, even though he, in that case, admitted, and threw the beer bottles, he admitted that he had been drinking, but it was not considered a public way. So that, I say, is similar to this, where we just don't have enough information that it's on a public way. The Commonwealth's not claiming that the sidewalk's a public way. And it's just too much.
It seems like you have an excellent case for trial. I'm struggling with the stage of the proceedings that we're at. So what is your home run case that I will read to say there was not probable cause to issue this complaint?
Well, I think it is Bellevue, which the Commonwealth relies on, and that it says it was obvious, and I quote, obvious that he had driven, that you have an eyewitness, even though that's at a different stage. Here you don't have that, and there's too much speculation, which the motion judge agreed with the defense attorney, that you don't have it. And that's why I went back and looked at 128, because late yesterday, because there aren't motion to dismiss. There's a lot of motion to dismiss cases, because frankly, that doesn't happen a lot, I think is what they say in some of the cases. It just doesn't happen. But here, there wasn't enough, unfortunately, for the police officer. Maybe if he'd written more information in his report, a little bit more about or the statements. Let's look at the statements. He says he doesn't know why he's there. He's near Expo, but he's waiting for a girl. He could have used drugs in the house and was waiting for a girl. We don't have an admission, and I don't think you can use those. I think you can't use those statements to just pile on and say he had to have been using drugs, there, because he didn't know where he was.
Can we use the fact that he said it was his wife's car?
Excuse me?
Can we use the fact that he said it was his wife's car?
You can use what's in there, but I don't understand what the difference is that it is his wife's car rather than his car that he was using. We could speculate and say the wife was inside the house. I mean, that's piling on, saying she was in the house and or a house nearby, and he used drugs waiting for her. I mean, there's just too much speculation that has to go on here to say, looking at the four corners of the what was presented to the magistrate in the complaint, including that the caller didn't live there. I think that is key, and I do point that out in my brief specifically. So other than that, if you have, I'm just going to check to see if there's nothing else that I should have said.
Do either of my colleagues have any questions?
I do not.
Counsel, you have 5 minutes you can use.
Okay, well, I will rest on my brief and ask that you uphold the motion judge's decision.
Thank you both very much.
Thank you.
The case is submitted.
We're live.
Thank you very much. We are back on the record. We're going to hear next the 5th case out of 6. The 4th case is getting moved to the end because of some technical issues. The 5th case that we're going to hear now is 2019 P1306, and it is John Doe number 356315 versus Sorb. And the case is impounded, so please no reference to names other than perhaps to expert witnesses and the like. We are going to hear first from Mr. Burkholder.
Good morning, Your Honors. Fred Burkholder on behalf of 356-315. First of all, I wanted to say that once I learned that the cases were paired, of course, I looked at both of them and curiously tried to figure out what the reason was. But nonetheless, I'll focus my arguments as I would ordinarily. I will stand on my briefs, and I think that it sets forth the issues that needed to be addressed. I do want to make some comments with regards to the arguments that were made by my sister in response, which I think are relevant. My first argument, of course, is whether or not SORB exceeded its authority when it promulgated 1.332, which is the repetitive and compulsive behavior argument. My argument need not add anything other than Judge Milkey's concurring opinion in 22188. That's my argument. And in essence, I guess I want to go a little bit farther, and I do want to say this. The purpose behind the statute, as I understand it, is, as stated by my sister in her brief, to protect the public from predatory acts of persons characterized by repetitive and compulsive behavior. The word "and" is important. Very recently, I got myself involved in doing appellate work for SDP Section 9 appeals. And during the course of that work, it became increasingly important. I realized that it is so important that sexual deviancy and the existence of either a personality disorder or mental abnormality was critical to whether or not an individual might have the inability to control their impulses. Why do I say all that? Because to me, that's what compulsiveness means. And the interesting thing about, or notable thing about both this case and the second case is there is no evidence of compulsiveness whatsoever. So I struggle when I write these briefs and review the hearing examiner's decisions, because what comes to mind is what an attorney who I used to practice with and is well known to this court used to say, and that's this: the agency plays fast and loose with the rules. And that's what I see in this case as well. What do we have here? We have a 28-year-old individual. Let's go from the beginning. He gets himself involved in an offense. He is charged. He's 18 years old at the time. He admits to some contact, which he says is consensual. And nonetheless, he is charged. That case is no problem. I don't disagree that the court can consider that. But remember his age. Remember that we're talking about a 30-year-old woman, and at that time, he was 18 and she was 19. So what comes to mind is, of course, what occurs in youth. All right, be that as it may. Then you go on and you look at the next offense. Clearly, the next offense was egregious. He pled guilty to it. He did his time and the like. But under the guidelines, and we all know that when you have any high risk factors that are applied, the first strike is against these individuals. And clearly that factor states, and I'm well versed in it, that when in fact there's a prior offense which you've been apprehended and charged, irrespective of conviction, that you can apply your aggravating weight. But again, there's no evidence of compulsiveness that is addressed. So,
Counsel?
yes.
I think the Commonwealth will argue that though Judge Milkey did concur that we've decided this issue in Doe number 22188. Do you think we did not decide this issue?
No, I don't. And what I think you did was you determined whether or not it was applied properly. I mean, the issue in that case was whether or not there was a pre-existing event, and the amount of weight that was afforded was aggravated weight, and yet there was no intervening discovery, as I like to call it, whether it be a charge or otherwise. And the court in 22188 said, no, the way the statute is written, you can't apply that weight. And I agree with that as it's written. That's when Judge Mulkey made his to me, beloved concurring opinion that attacks the validity of the regulation. You know, I've been doing this work for about 2 or 3 years now, and I do a lot of it. And it just defies me that, you know, I get the phone calls from these guys that are homeless because they're level 3s. And I have to face the situations where there's no place to put them. There's nothing to do with them whatsoever. They made mistakes and the like. The next guy is 72 years old. This guy is young, but nonetheless, he did something as a youth. He then did something that was egregious, but he only got 4 years for it. And then he turns around and he's labeled with a level 3. And again, I come back to the fast and loose. Okay, no proof of behavior whatsoever. Then we get to the articles, and specifically the article Predicting Relapse by Hansen, who everybody recognizes as an expert, period, who says there's no correlation between, and I want to get it right because my sister paraphrased it better than I did. Where did she say it? She said specifically, of course, I can't find it when I want to. Oh, little correlation between force, criminal history, and violence. That's what that study says. Now, I didn't write the study, or I didn't write the regulations. Certainly there are psychologists that are on the board that did so. But you know, like Hansen testified, and I'm sure you've all seen his testimony from an unrelated case, they made some mistakes. And as a result of that, you can't encompass this. I come back to one thing when I look at these cases, and that's this. Let's do an individualized assessment. If I could have an expert in every case, let that expert turn around and take a serious look at this situation and address the issue of compulsiveness, then I would feel much more comfortable saying there wasn't an abuse of discretion, there wasn't a mechanical application, and we should defer to that technical expertise. I had a case once that was a gentleman who was involved in economic profit from basically promoting prostitution. I asked for funds. I was denied. I went to the Superior Court. The Superior Court judge looked at me and said, you know, I don't see any evidence of compulsiveness. Let's send it back. We then brought in one of the leading experts in this area from Harvard University to testify, who said, you know, there is no evidence of compulsiveness. So my point is very simply this. Without that evidence, to saddle these guys with level 3s for at least 3 years, and more likely at an age 28-year-old man for the next 20 to 25 years, is a violation of due process.
Counsel, say hypothetically that at least one of my 2 colleagues agreed with my brilliant concurring opinion. What flows from that in this case in terms of remedy and so forth?
Well, I mean, I would like to have it sent back, and then I would like to have an expert evaluate this man and determine whether or not he has compulsiveness. And if he does, then so be it. At age 28, with the egregiousness of his offense and the fact that he's got some, which I'm not disputing, some aggravating weight on a number of the other factors, then maybe a level 3 is warranted. But let's take an individualized look at this guy rather than just pigeonhole it. And you know, when you have a hearing examiner who makes a, I want to read what she said with regard to the study. This floored me. And what my colleague said in the next case even was worse. It says, as these articles do not specifically address sex offender recidivism and or dangerousness, I give them little consideration. Even the Superior Court judge said, I don't think so. But based upon what I have to do, based upon the existing law, I have no choice but to affirm the decision. So
the board will argue, I predict in a few minutes, that the articles you're relying on were considered in the regulations, and that that therefore there was nothing extra for the hearing examiner to consider. So what's your response to that?
My response is as follows. If you look at factor number 8, factor number 9, and factor number 10, the relevant language is offenders who use threat or use or threaten to use violence or weapons or cause bodily injury during the commission of a sexual offense are more likely to reoffend and present an increased degree of danger. That's 8. 10 is lawlessness and antisocial behavior correlate with risk of reoffense and degree of dangerousness. And 11 is an offender is more likely to reoffend and present danger. They previously demonstrated he acted violently. They got it wrong. That's my opinion. They got it wrong. And Hansen is an individual who will admit that he's wrong. He's done so on the witness stand. That testimony is, we argue about it, and only to mention the next case, they don't want that testimony in for love or money. In the next case, it was proffered, and that attorney, who is someone I have tremendous respect for, didn't push it. It's not in. I can't argue it. I know it's waived, but the reality is they fight like heck to keep that out because, he's respected. He knows that they made mistakes, and he also knows this is an evolving science. Here's the last thing I want to say in response to that. These are supposed to, when I first started doing this work, my mentor looked at me and said, Fred, where is the scientific basis? This is supposed to be an empirically based classification. And that's what I'm saying to this court is maybe it's time to go back and look at the regulations again. I know it was only 2016, but science evolves from one day to the next, just like our laws do. Maybe it's time for them to do that, or give us funds on each case so we can have an expert who is versed in the changes in the law offer testimony.
Okay, counsel, Dr. Hansen is obviously well respected, and I'm sure the board would agree with that. That doesn't mean the board has to accept his opinions, either oral or written.
I don't disagree.
So what is it? You say the hearing officer, summarily dispensed with this. What is it that the hearing officer had to do in terms of grappling with this study?
Well, I look at the decisions that are relevant to this, and there are 4 that at least I'm aware of. The first one is 205-614, where the court stated the ability to consider other useful information not specifically contemplated is an important safety valve protecting a sex offender. In 15164, the court said it was arbitrary and capricious for the hearing examiner to reject the evidence without citing any studies to the contrary. And the failure to heed the emerging scientific consensus in this area undercuts Doe's due process right to an individualized hearing. Then in 136652, the court said the SORB's failure to consider studies referenced in the record showing the differences between psychological development and outlook in mature adults when classifying sex offenders was arbitrary and capricious. And then the very recent case of 524553, which I'm sure you received with regards to my 16L letter, that basically said the flaw in Doe's argument is that he points to nothing in the articles actually addressing this issue, nothing explaining how the circumstances of having offended against only intramural victims should be weighed within the system. Because the articles shed no light, the opinion goes on to say, Doe, the examiner did not err in giving the articles little weight. So I guess what I think needs to be done is if you're going to reject it summarily, just like when you do an expert opinion, you got to have an articulable basis. And just to say it's previously been considered or the 2016 regulations came out and now we all need to bow down to them. This is way too complex of an area and way too important of stakes to just defer to regulations that were written 4 years ago.
Can I take you back to the first issue and ask you to respond to Ms. Nixon's brief where she says that the issue is not properly before us because you didn't file a declaratory judgment action below?
106738. It says that I'll paraphrase it because I can't find it. I have to say this much to you. I have so much respect for this court trying to do 5 hearings in one day. I'm only trying to do 2, and I got more paper than I need. That said, I used to argue for the Sixth Circuit in Cincinnati when I first started doing this when I was 23 years old, and they'd walk in with a stack of briefs as tall as this, and I was in awe. And I thought, how do those people digest that material? Well, you're better than I am. That's all I can say. Basically, 16738 says, the statute says it may be addressed by declaratory action. It does not have to be. It's a quintessential judicial interpretation, and as such, it's properly before the court. It's been addressed. It's there. It's in my brief. I don't have anything to add to it. And conversely, just like, you know, my sister made some arguments that I do agree with. You know, I mean, but there are some that
Do you think he should have been classified as a level 2?
Yeah. Yeah.
Okay.
Level 2 would work. I mean, certainly he doesn't deserve to, the public deserves to know about his history, especially given the egregious nature of his own, his governing offense and the fact that it was in public and it was a stranger and da-da-da. Certainly they should be aware of him. But I don't know that this court really has a realization of the impact a level 3 does. And I frankly didn't until the recent past, when I started getting some phone calls from guys that were recently released that had absolutely nowhere to go, nothing to do, were at risk, where one guy got attacked. He's out in Springfield.
Look,
I sent him into work.
Counsel, given the change in the statute a couple years ago, where level 2s are now put on the internet, is it really that big a difference?
It is.
Level 2?
It is. And the reason it is because landlords, hotels, even Catholic charities, anybody that's going to assist these guys, a level 3, they just jump back away from because of the active dissemination and because of the stigma that attaches to it. Level 2s can find a place to live, they can find a place to work at, and they can try to get their life back on the road.
Okay, Counsel, last question from me, and I'll check with my colleagues. You referred to the hearing officer as a she. I think it's a he.
It is.
Yeah, I don't know I don't know that name. I mean, I know it's.
Yeah. Okay. I just wanted to see if you knew something I didn't.
No, I apologize.
Do either of my colleagues have anything else?
No.
Thank you very much. We'll hear from you eventually in the next case. Now we'll hear from the board.
Thank you, Your Honor.
Good morning, everybody, and may it please the court, Nicole Nixon on behalf of the appellee board. Just as initial matter, the hearing examiner is a man in this case. My brother keeps referring to him as a female, but it is a man. And to respond to your question, Justice Blake, about whether this issue is properly raised, the first issue concerning factor 2 is properly raised in the first instance. It's my initial argument that it's not. This action should have been filed, or this claim rather should have been filed in Superior Court with a declaratory judgment count. And that's because this isn't merely a matter of interpreting a statute or a matter of statutory interpretation. Rather, to attack a regulation like this, we need to develop a record in the Superior Court to determine whether the board's definition of repetitive and compulsive behavior is adequate and in line with the scientific research. We don't have that here.
Why isn't this a pure question of law?
Because we're looking at the adequacy of a definition of repetitive and compulsive behavior. And here I'm arguing that there is a definition to define compulsiveness in the sex offender recidivism context. Now, if you want to attack the validity of that definition and say that that's against the research or against Dr. Hansen's interpretation of that research, then that needs to be done through the declaratory judgment action in the Superior Court, because we need to get that evidence on the record from both the plaintiff's counsel and the board to determine whether that definition of compulsivity is adequate.
Are you saying that if we rule in the board's favor that this particular Doe defendant could go back to a declaratory judgment action in the Superior Court and raise this issue?
I don't believe so. I believe if you rule in the board's favor in this case, then that could not be done by this particular Doe defendant, no. And I guess my overall argument is that if you are going to decide the first issue, meaning the adequacy of the compulsiveness definition in factor 2, then Doe hasn't met his burden to prove that it's inadequate in this instance or that compulsiveness is excised from the statute. I think, it's a different argument to make to say in a declaratory judgment action that the compulsivity requirement or definition of compulsiveness in Factor 2 is inadequate or against the research by Dr. Hansen or other researchers in this field.
So I'm trying to understand though, if who is it you think could bring the declaratory judgment action? Is it somebody who has been convicted of a sex offense that would subject them to the board, but they haven't yet been classified?
Sure. I mean, anybody who, any sex offender who has a SORB hearing then brings an action in Superior Court through 30A or other means to attack the validity of that decision. I believe there actually is, not that it's related to this case, but I believe there actually is an action in Superior Court attacking the validity of Factor 2 at the moment from another offender's attorney based on another offender. And like I said previously, the board did not exceed its statutory authority or excise the compulsiveness requirement out of repetitive and compulsive behavior. There is a definition to define compulsiveness in the sex offender recidivism context.
Should we stay this case for those declaratory judgment actions to go forward?
I don't believe so, Your Honor, because I don't believe it's properly pled in this matter. I think if we're what we're looking at is, Doe's argument in this case, and if you're going to take that argument up, then we're looking at the adequacy of the definition as it stands today. And Joe just hasn't met his burden in this case of proving that the board did not adequately define compulsiveness or excise the compulsiveness requirement out of the statute.
So he says that he's preserved this challenge to the validity of this 1.33 open paren 2 close paren by arguing it in one of his pleadings below. So what do you say to that?
Sure, and it was argued below, but not through a declaratory count. I believe if you look at the plaintiff's motion for judgment on the pleadings in this matter, they talk about whether there was evidence to support the application of Factor 2 in this matter, and they say that there isn't sufficient evidence of compulsivity to warrant the application of Factor 2 in this case. It doesn't talk about attacking the validity of the regulation. And even if the court were to entertain the merits of this case, meaning that what you do view this as a properly raised issue, then again I go back to my argument that they haven't met their burden of proving beyond a reasonable doubt, that the board excised the compulsiveness requirement out of the statute.
What you said that there should be a record developed on this issue. What facts do you think are relevant to, and what facts would a reviewing court want to look at in order to assess the legal question of whether this regulation was ultra vires?
Sure, and Your Honor, if you look at it in that, I guess in that lens that this regulation was ultra vires, which you obviously do because I've read your concurring opinion in 2218, then it's one of statutory interpretation, and the board's argument would be that there is an adequate definition of compulsivity. It doesn't track the definition of compulsivity in the sexually dangerous person realm or a clinical definition of compulsivity, but it doesn't have to. The board has the authority to determine the appropriate definitions of things that the legislature has indicated should be looked at in sex offender recidivism cases, and it did that here. There is an adequate definition of compulsivity, and the compulsivity requirement is also spoken to in the gradations of weight given in Factor 2, meaning like in this case, if somebody's been confronted and investigated about their sexual misconduct and then subsequently reoffends, aggravating weight can be given, and that was the case here.
Counsel, I believe in the case that Judge Milky wrote the concurrence, there were 8 days between the two sexual assaults. And here, roughly, my math is about a little over 3 years. Does that matter on the compulsivity question?
I think that matters, Your Honor, but I also think what matters more is the fact that this particular Doe committed an act of sexual misconduct, that he wasn't convicted of that misconduct, but the hearing examiner found the victim's allegations in that case to be credible. He was charged with a sexual offense, and undeterred by that charge, he subsequently reoffended, this time against a stranger in a public place. So that shows that even when he's notified that his behavior or sexual misconduct is inappropriate and he could be facing criminal charges and convictions and consequences from that behavior, he's not able to control his behavior and he goes on to reoffend. I think
Well,
that's
what if the gap, I don't know, instead of 3 years, what if the gap was 13 years? In other words, is there a line at which the time delta vitiates against compulsiveness?
That's an interesting question, Your Honor. I'm not sure if it's particularly relevant to this case where we do have the fact that he was notified that his behavior is wrong by that criminal charge and he goes on to reoffend again. But I do think, you have to look at the facts of the case. And in this particular case, and I'm sorry to keep going back to this particular case, but that's what we're here for. There was competent evidence of both repetitive and compulsive behavior based on the language of the regulation.
Okay, but name me an example of when the board would find that the compulsive prong had not been met when there was a repeat offense.
And again, Your Honor, I don't necessarily want to speculate to your question.
Don't speculate, just give me an example.
But respectfully,
if you can't come up with an example, then you would seem to have written it out of the statute.
Respectfully, Your Honor, you're asking me to speculate about an individual, about a case that we don't have before us today. These arguments are supposed to be based on an individualized assessment of an offender and the evidence before the board at that time. If you want me to speculate and answer your question.
I mean, and Judge Milkey is right. If you can't give us an outer boundary, then it seems like you have excised the compulsiveness. I mean, if it's a 50-year interval, would that maybe cause you to have pause? I mean, is there you pick the most outrageous example you can come up with, but any example.
Sure. I guess if you want to look at the timeframes and judge the definition by the timeframes, then it may be a 20-year gap between offending behavior and then reoffending. But again, we have to look at the evidence that's before the case to determine whether it's sufficient evidence to support application of factor 2.
I mean, is it, as I understand the board's regulation, it actually cuts the other way, where the longer the time and availability for moral reflection, the more it's compulsive. So I thought where you were going to go was that if it was done, back to back, 2 sex offenses, within an hour, then there wasn't time to morally reflect on the wrongness of the conduct.
Your Honor, I guess, that would be a closer question as well. If somebody commits multiple sex offenses in one night, against multiple victims, then there may not be evidence of repetitive and compulsive behavior there, where there's not time and opportunity to reflect on the wrongfulness of the person's conduct and what they're doing is wrong and then reoffends. That may not be a situation where factor 2 should be applied.
But isn't that, shall we say, counterintuitive that the legislature intended that person not to have an aggravating factor when they're on a rape spree?
Well, the legislature is concerned about people who commit predatory acts defined by repetitive and compulsive behavior. They didn't define what determines or what's considered to be repetitive and compulsive behavior. And I think that's the crux of my argument here, is that the board should have the authority to define this term as repetitive and compulsive behavior. And it did so here. I think to attack the adequacy of that definition based on, a scientific research or say Dr. Hansen's testimony, which I would remind your honors that it's not before the court today. Dr. Hansen's 2014 transcript isn't before this court today. Then that would have to be done through a declaratory count where the evidence is presented by both parties.
So counsel, when was the first time the board defined this factor 2 repetitive and compulsive? Was it 2016 or was it earlier?
It was earlier, Your Honor. In 2016, the amendments to factor 2 added in the gradations of weight given. So where somebody can give an increased weight for actions that occur or reoffenses that occur after somebody's been investigated or confronted about their misconduct. And then the gradation of weight where the most weight can be given if somebody is convicted or charged of a sexual offense and then goes on to sexually reoffend. So those gradations
the legislature so they've had years of opportunity to change this and they have not.
I'm sorry, who are you speaking about?
The legislature.
Oh, I'm sorry, I just misunderstood your question. Yes, that's correct. The legislature enacted the sex offender statute, I believe in the most current version, at least in 1999, and it hasn't made any amendments to it, to my knowledge, at least in regards to Factor 2 since then.
And how does the fact that, I'm sorry, Justice Milky, go ahead.
No, go ahead. You.
How does the fact that the scientific article that Attorney Burkholder discussed in his papers, the fact that it predates the amendment, you make an argument on page 26 of your brief about that, but as you just acknowledged to Justice Henry, that the statute itself has been in play for a multitude of years. So some weight should be afforded to that article, right?
Well, I think my main argument as to that issue is that this 1998 predicting relapse article has been around for many years. It's actually used in the formulation of the board's regulations and guidelines. Scientific articles in cases where the court has said these scientific articles need to be addressed in a decision, or the science surrounding the article be considered in the overall decision, is when the particular facts that are dealt with in that scientific article aren't dealt with in the regulations, such as somebody's age or somebody's gender or somebody's.
So you say it's already folded in. It's already baked into the cake, if you will.
Exactly, and there's specific, I guess, points that my brother points to in the article that he says conflicts with the regulations. But if they do conflict with the regulations, then the regulations which are valid and in place should be followed by the hearing examiner.
I don't have the language right in front of me though, but the hearing examiner just dismissed the article on a ground that the Superior Court judge found was just wrong. So what do you say to that?
Sure, and Your Honor, I'm not gonna say that the hearing examiner's treatment of the article was particularly well thought out. I don't think that I can make that argument in this case. However, where the article is already formulated and already taken into account within the regulatory guidelines, then any mistreatment of the article isn't erroneous in this case, because it's already treated and it's already viewed within the regulatory guidelines. And the hearing examiner does have a duty to apply the guidelines as written, and there was sufficient evidence to support the application of factors 8, 10, and 11 in this case.
Okay, if we were hypothetically, and this is pure hypo, to send this back on the compulsivity issue, do we need to resolve the question of the scientific article from Dr. Hansen, or is that something that the hearing officer should at least take another look at, given that the reason he rejected it was found erroneous?
Your Honor, if you're going to be remanding the case back because there's not sufficient evidence of compulsivity, then the hearing examiner can obviously take a second look at and readdress the predicting relapse article in that remanded decision.
Okay.
As to factors, are you done, Justice Milky?
Yes, I was going to ask you if you had any more questions.
As to factors 10 and 11, Doe argues that the hearing examiner failed to indicate the amount of weight she assigned to those factors, and that itself is a separate error. What do you say to that?
Sure, and again, I respectfully, the hearing examiner in this case is a male, not a female.
I don't even know. Okay.
But in response to your question, I think the hearing examiner appropriately explained his reasoning as to why he applied factors 10 and 11 in this case. He didn't give, an indication if he applied it with an increased weight or minimal weight. And I think where he didn't give that indication, he applied it at the factors threshold weight.
I didn't hear you say that
I'm
last part.
sorry. Where he didn't give an indication that he applied these factors with an increased or a minimal weight, he applied it at the factors threshold weight, and he baked that weight into his overall balancing of the factors in this case.
Do either of my colleagues have any further questions?
No.
Seeing none, I want to thank you both very much. We'll see Mr. Burkholder in a minute, and the case is submitted.
Thank you.
We are live.
Thank you very much. We are back on the record in what was to be our sixth case. It is now our fifth case. It is 2019 P1406. And the case is John Doe number 24801 versus Sorb. And I would just remind the parties that the case is impounded, and please no references to the name of the sex offender. With that, I will turn it over to Mr. Burkholder.
May it please the court, Fred Burkholder for Doe 24801. First of all, I wish my brother would have heard my arguments. That way we could have saved some time and addressed what's more important. I want to start by reading you something from my brother's brief. This is at page 19. This is the crux of my problem. The hearing examiner was not required to accept the findings of the articles the plaintiff submitted, even in the absence of contrary evidence. Since the hearing examiner was required to utilize the board's statutory and regulatory factors in determining the plaintiff's final classification, she could ignore expert evidence where the application of the board's factors resulted in a different conclusion as to an offender's risk of dangerousness. Citing Doe 10800, that's my problem. In essence, it magnifies itself. In this case, we're talking about advanced age. We're talking about Factor 30. Factor 30 in no way, shape, or form discusses age 70. It stops consideration or addressing it specifically at age 60. The articles that I submitted make it very, very clear that from 60 to 70, and specifically at age 70, risk drops to virtually non-existent.
Mr. Burkholder, two points that I think to put this particular sentence in context that I would like to ask you about. The first is that the board suggests that this predated their regulations, so not dissimilar from what we talked about in the last case. What is the impact of that? But more importantly, that the article in question was based on a group and not an individual assessment. That's what I read the thrust of Sorb's argument to be on this point. So could you address those?
Well, I don't disagree that the studies were meta studies, and as a result of that, they certainly did look at a number of different individuals. I mean, from a scientific standpoint, if I was trying a case and I had an expert on the witness stand and I was cross-examining them and I was using a treatise, and I would say, well, you're testifying with respect to this particular individual, but is he an anomaly? Is he an outlier? Versus what is the subset or state? That's the first problem. The second problem dovetails into one of my arguments, which I know and I agree completely with my brother that because an esteemed counsel, why I have no idea, did not reassert the argument for funds for an expert. I lost that argument and it wasn't raised, and I know I don't have it, but I also know that this court, when things are important, at times sidestep that and look forward. And that comes back to the argument I made in the first case as well, which ties right into Your Honor's question, which is these cases require individual consideration. I don't disagree. All I'm trying to do is get the hearing examiner's attention that, the factors don't encompass somebody that's 70 years old. And as a result of that, maybe you might want to take a more serious look. And to the hearing examiner's credit, they gave this factor full aggravating weight, but that isn't enough.
Okay, go ahead. Sorry.
Because full aggravating weight still, when balanced against the other factors, and I'm going to say this just before I go on. How do you balance something that's considered? I don't get it. How do you balance something that's applied? I don't understand how you can balance.
Counsel, can I maybe offer a thought on that? Which
Please.
is the offending history of this particular client is really bad.
I don't disagree.
And yet he got a level 2, and he presumably got the level 2 because of his advanced age. So how do you address the argument that the hearing officer did take this fully into account and gave your client a great deal of credit and knocked him down from a level 3 to a level 2?
It was entitled to more. I mean, let's look at the nature. Let's take a look at what 496501 looks at.
To more? I just didn't hear you.
It's entitled to more credit.
More,
and
okay.
I'll tell you why. Let's look at how 496501 addresses assessment of dangerousness. They look at the nature of the offense that is likely to occur. Prologue is a past, correct? and the dangers that would result in it. The offense in this case was characterized as against an extrafamiliar member. It might as well have been, I forget the word that I'm looking for, but it was a live-in situation, and it was egregious. I don't disagree. It's probably one of the worst cases that I've read in that regard. But is he going to have the opportunity to commit that offense again? I think the available target pool is so nominal, given his age, given the fact that he got himself in contact with the victim in a live-in relationship. Those factors in and of itself detract from any exposure and any dangerousness that this court or a hearing examiner would have to assess. And then I go back to his age. I mean, at age 70, statistically, from what these studies suggest, people at that age virtually have no sex drive whatsoever, and they don't even have the physical capability.
Careful.
Well, yeah, I know I'm not that far either. I thought about that, but and you know what? And I dearly respect my esteemed colleague, because he made two very good points in his argument. He said, first of all, he was 50 when he committed the first offense, and secondly, he picked a prepubescent victim. So certainly those both suggest deviancy, and I'm not arguing with it. And I understand that, and I respect his argument completely. 70 is 70. I'm sorry, and I think that it really makes a difference. And if nothing else, then have an expert take a look at him. Have an expert take a look at his physical situation. It's not before the court, but his physical situation is not good. And why that wasn't introduced either, I have no idea. But it wasn't. Being primarily an appellate attorney in these cases, I love the people that do the work below me. But when you get to sit back and crapshoot what I would have done or I wouldn't have done, and not in the heat of the moment, I used to try cases with Barry Wilson. It's easier to sit back and look and say, well, why did you do this and why do that, than when you're sitting there trying to do it, or you've got 10 cases you're trying to.
Counsel, one of my colleagues has a question.
So I don't understand though how you're basically on that issue about age. You're basically saying that every person over 70 would need to have an expert examine him before the board could proceed. Am I understanding you correctly? Like, what's the showing he made that's different from that?
I want to stop short of saying that, but I want to say then have the factors address more specifically what happens to an individual at age 70, consistent with what the studies show. Because the regulations, even though you get full weight, do not say that. Look, the Superior Court judge that reviewed this agreed with me, and I'm sure that this court looks at it and says, there's a problem here. And the problem is, again, comes back to the argument I made in the first case, which is fast and loose. All right, we got a regulation. It says it's 60. Here's the situation. It says because he committed an offense at 50 and it was a prepubescent victim, then we don't have to give it a serious look until 60. It says nothing about 70. I can pigeonhole him in that. And then I can say considered on the rest of them without assigning any weight. And that's enough for me to say, you know what, he's a level 2. Well, I mean, level 2 means medium degree of dangerousness. I go back to the 496501 offense. Let's look at the degree of dangerousness that this individual is going to present. First of all,
So you think he's a level 1?
What's that, please?
You think he's a level 1?
Yeah. And I will say this, of the other individuals that I've had that have been age 70, not one has been a level 2. Everybody's been level 1.
So when I read Justice Feely's second decision, and I think he used the words constrained,
Exactly.
What in addition to the arguments you make, the things that I read that were of concern to him, and I think are fair points, are that for whatever reason, he rapped, he didn't have probation, so there's no supervision. His community support was, I'll describe it as weak at best. I mean, there were other factors that vitiate in support of a level 2. So the balance, you seem to, with understandable reason, put all your eggs into the age basket, but there are other factors here. If these other things were in place, perhaps Judge Feely would have seen it differently, or the hearing examiner would have seen it differently.
I don't disagree, and what I'm trying to find is what the hearing examiner actually said with regards to the final assessment. And basically what it said was,
Is this on the remand?
yes, on the remand, the conclusion was, given the proceeding and while remaining mindful of excuse me, strike that. While remaining mindful of Doe's age of 71 and his having a support system in the community, nonetheless, he has been incarcerated for over 2 decades with his ability to vocationally control any emergent deviant sexual urges while in the community setting. Consequently, after careful consideration, the high risk and elevated risk factors balanced against his history and applicable mitigating findings, I find it's clear. So basically what they're saying is he's untested. And as a result, because he's untested, then I can say this. I mean, I'll go back and I'll talk to you very briefly with regards to the factors and what my opinion is. Repetitive and compulsive, it says considered. At best, it's a threshold finding, if in fact it's even a valid guideline, because there's no evidence of compulsiveness like there wasn't in the other case. All right. Adult offender with child, I agree with that. It's pubescent child. Relationship, you know, I think the degree of intimacy might suggest that it might not even be extra familiar. It might even be, you know, more of a why can't I find the word for that? Incestual relationship, simply because he lived there for such a long time. Alcohol 5 years ago applied. I mean, 5 offenses. When did they occur? 25 years ago? I mean, the guy did 21 years. Contact with the criminal justice system considered, same thing, 14 charges. I mean, the man was sentenced on 9/7/8/97 to 8 to 12 and 8 to 10. He did 21 years and didn't get out until 6/1/18. So we're looking at, let's talk about what's current. Physical contact, it's egregious. I mean, I'm not going to disagree. It's a terrible, terrible, terrible offense. His age we've talked about, and the home support, there's not much for these guys to be able to do after they've sat for that long. I have conferences with them. They don't know where they're going to go, what they're going to do. I actually had one SDP guy look at me and say, Fred, where am I going to go? If you get me out, where am I going to go? And that's the reality. So I don't think that the other factors support a level 2 either. I have problems with just saying applied or considered, because like the last case that I directed the court's attention to in my 16L letter, I mean, the court says assessment of whether a hearing examiner's findings would support a moderate risk of reoffense and moderate degree of outcome is complicated by examiners only stating factor was considered rather than ascribing specific weight to each. So, you know, I mean, this is supposed to be empirically based. The only evidence that I've got is a 70-year-old man that Hansen says has no risk.
You've got, below there were 6 articles that were offered. Are you on appeal? You're arguing just 2 of them?
You know, there was only 2 raised at the Superior Court level.
Okay, all right.
And as a result of that, I deferred to, again, I have tremendous respect for my esteemed colleague, and he said they were waived. And I found the most current decision, which is 523281, was decided in 2018. It says, you didn't raise it, don't talk about it.
Okay. And you say there's no remedial basis for internet availability of Doe's information, and it cannot be justified and becomes punitive. Can you explain a little more what you are arguing there?
Well, basically 496501. First of all, the test that's offered in 23656, that doesn't mean anything to me. I mean, it's a nice semantic test, but I don't think it really gets to the heart of what 4966501 was. All it did was say, was it properly applied? Was there substantial evidence and efficacy? It didn't say anything to me. It's cited by my sister and brother in every one of their briefs, but it doesn't mean a lot to me. What means a lot to me is 496501 and the companion case of 137037, both of which say to assign an individual's determine whether or not publication is or internet dissemination is warranted. We have to look at the nature of the offense and the type of offense that they would commit. This particular, and then we have to look at efficacy. I've had cases remanded by this court for efficacy.
So is that, to the extent the board is reasoning that if somebody gets involved in a relationship with him and they have young children or grandchildren, that the publication would be helpful, or people visiting those people, why is that punitive and not remedial?
I think it's punitive because it will preclude him from finding any place to live period, and it will preclude him from I'm not certain of the status of the law presently. It might even, I think level 3s are precluded from nursing homes. I'm not certain about level 2s. His health, although it's not before the court, is not getting any better. That's how I deem it to be punitive. Remedial is notification. I mean, this is not a stranger situation. This is not even really an extra familiar situation. This is a live-in situation. So unless you're going to, you know, unless you're going to go on one of the dating sites and you're going to do a star that says, hey, you know, this individual has this, I don't know what it solves. I just don't know what it solves. And when you balance it, it's different. I can see, like in the last case where it was an egregious offense in public and the like, but this wasn't. I mean, the poor victim, I can't have enough sympathy for, but the reality is that it was mom in the house. Makes you wonder what was all going on there, but.
Okay, counsel, I'm gonna have to stop you there unless my colleagues have any questions. Seeing none, we're gonna hear from the board.
Thank you.
I'm just waiting for the timer to go. David Chennai for the board. Good afternoon, Your Honors. DO 496501 has an interesting paragraph in it. And it says specifically, when an offender's been incarcerated for a long period of time, it's incumbent upon the board and permissible for them to base their decision on the individual's prior behaviors prior to the incarceration. In this case, the idea that this is intrafamilial is kind of misleading because this individual moved into the home and within 7 months was sexually abusing this girl. I think that is indicative of almost predatory behavior at that time. What's important about that, and that's why the intrafamilial and factor 7 is in these kind of situations, it's if you commit the sex offenses within 2 years of moving into the home, it's not an intrafamilial relationship. And again, it's to prevent that type of predatory behavior where someone finds a family, has a deviant cycle with a young child and sees the child in the family and immediately starts sexually offending against that child, which essentially is what happened here. Now, the hearing examiner had great concerns, I believe, and again, the age issue, they did reduce down to a 2, but there's still concerns. His sex offending behavior was extremely deviant, and because of that, and if you look at his time incarcerated, he didn't do any type of programming to address that issue. So when he comes out at 71 or 72, however old he would be when he came out, we know he had a prior deviancy towards children, and we don't know if he's addressed it in any way or if it's dissipated. The mere fact that someone turns 70 doesn't necessarily mean they are incapable of committing a sex offense. And that's why the factor 30 specifically says, when you look at someone's age, you also have to look at whether or not they have deviancies. You have to take that factor in correlation with all the other factors that may be applicable here. And I think that's really the gravamen of this case, is the fact that he had a deviant issue back at the day. He's been incarcerated since that time, has done no type of programming to address it, and now is going into the community. And because he's wrapping up, he's not even going to be on probation.
Counsel, how does his flight to Florida after the conviction but before the sentencing, how should that be considered or factored in?
I think that goes more towards back then his behavior. I don't know that it really factors in that greatly, other than showing a past criminal type of behavior, fleeing the Commonwealth. But if this, if I've had a case where the fleeing was really important because the individual had left the country for 3 years and had to be extradited back. This was a short period of time. I'm not sure that it has that big an impact on the overall assessment of this case. And that's why I didn't really focus on that, just other than to mention that that's what happened during that time frame. And I think I did mention it more or less to give a correlation of why the sentencing was a little bit delayed as opposed to the convictions. But that was really the only factor for that. But in the end, the board would state that the hearing examiner's decision was rationally based on the evidence. They gave great credit to the age of 70 and did reduce it from a 3 to a 2, even though the individual has shown a prior deviancy, has not addressed that deviancy, and is going into the community without any supervision whatsoever. So unless there's questions,
Counsel, the articles that he relies on about people over 70, do they deal with people who have the deviancy issues that this Doe has?
Well, specifically, no. Both of the studies he's citing, and they were part of Factor 30. Factor 30 also relied on a number of other studies. And again, the board's not required to rely on only one study. They relied on, I believe, 9 other studies. They were just 2 of the 9, and they didn't specifically deal with deviancy and aging. What they dealt with was the aging process on sex offending behavior. And that was based on general groupings of people as opposed to individual peoples. And Hansen in every one of his studies will tell you that even though you're using groupings, individuals may have different results outside of that grouping areas. He's never said that the groupings are absolutely the rule. And in every one of his studies, he will tell you that there are people who fall outside of those rules and outside of those studies.
Okay.
And again, that's what Factor 30 is trying to focus on, finding those individuals.
Okay, counsel, what if, just to make this a little more dramatic, he had been 90 and not 70?
I think when you get to 90, and again, based on disabilities and everything else, which usually occurs with 90, you would see, I think, even a greater reduction. I mean, I think
no,
that's
I understand that, but could the board just say, okay, I give you, our reg says 60 and you're over 60, I give you the full mitigating weight, without taking into consideration, say, an article by Dr. Hansen or somebody else that there are no sex offenders that we can trace there above 90.
That argument, that questioning, it goes outside of the idea of the regulations, which is to be applied in a common sense fashion. I think if you bring in a 90-year-old who hasn't had any issues, he's 90 years old, I don't think you're going to find a level 2 or a level 3. Now, if he committed his first sex offense or committed a sex offense at the age of 88, that might change that. So, I mean, it's really a common sense approach. I think the board does take into account as people age, and the older they get, the less their risk is. Here, the difference is that he's been incarcerated for the last 2 decades. And we know he had a deviant cycle. We know he had deviancies, and we also know he didn't address those deviancies. And we don't know physically if he has anything other than being 71 years old that would impair his danger or risk in the future. I think without that, again, the board is, I think in this case, was generous to make him a 2 based on the evidence. And again, it really comes down to his age is what reduced it from a 3 to a 2. If he had been living in the community for the last 15 years and had done nothing, I think that would have been down to a 1, or maybe even not register. But that wasn't the case here. And I think, again, these are case-by-case analysis. That's the whole idea of the individualized assessment of these characters. And again, Factor 30 is trying to make that individualized findings on each offender, whereas these studies are based on groupings. And again, Hansen will tell you in every one of these studies, there are individuals, and that's what we were trying to narrow down, is getting to those individuals who may not follow that grouping.
Okay, counsel.
I'm sorry, go ahead.
No.
Are you aware of a case where the Doe was given full mitigating weight for age that on balance was stronger than the other factors, that it ticked the balance in favor of Doe?
What I'm seeing with the number of reclassifications we have had, age has played a big role in huge reductions during that. For offenders who are aging, who have been staying offense-free, on these new reclasses that we were ordered to do, I'm finding reductions from 3 to 1s and many of them which don't have to register anymore. And age is playing a big factor in those cases.
And so it's changing their
So I would say,
level.
yes, I'm seeing that.
So they're
Excuse me?
being reclassified from a 3 to a 2 or a 2 to a 1?
Right, because as you know now, every 3 years, an individual has a right to request a reclassification.
Right.
The board has to prove by clear and convincing evidence their current danger. And I'm finding that the older offenders are getting much greater credit than they used to get under the old system. So you're seeing large reductions and many people now coming off the rolls based on 2 factors, really, age and offense-free time in the community. Now, again, if someone's 75 years old, but they've been committing domestic abuses all the way through their 70s, and they're 74 last year and they did it again, that's kind of a situation where the board may reduce them to a 2 or a 1, but is not going to relieve the registration because he's showing some propensities towards violence, which correlates with possible sexual offending. But for the most part, on these reclasses, the age and time in the community, offense-free, are making big inroads in the reduction of sex offenders enrolled and or reductions in their original final classifications.
Okay,
Go ahead.
Counsel, can we turn to the compulsiveness issue? And as I think you surmised, at least one member of the panel thinks the regulation is ultra vires. Say hypothetically, and this is pure hypo, you had at least 2 members of the panel come to that conclusion. What would follow from that as it applies to this case?
Well, first I want to say, Justice Milkey, I think, do you remember about 10 years ago, we were arguing at New England College? You sat on that and we had the same exact discussion. I think it was about 10 years ago. So I know that this is, when I saw your concurrence, I said, I called my office and, Justice Milkey has been talking about this for a long time. But the reality is 22188 specifically says that there is a threshold weight at this point for the type of actions this individual did. And the hearing examiner applied it at that rate. So technically, and I know you're not in total agreement, technically they are within the findings of 22188. So that would be my very cautious answer to that question.
Assume at least one member of the panel does not agree with that.
Well, this is where I always do my fallback, which is, Judge, that's why you're sitting there and I'm sitting out here. I can't tell you what to do or how to make the decision. Just like I can't tell the hearing examiners what to do and how to make decisions. Because if I could, there'd be a lot different decision making, I think, in a lot of cases.
What makes this case somewhat different than either 22188 or frankly the case we just heard before this is that there were more than 2 offenses at issue.
Correct.
There were repeated offenses in over a 5-year period with some evidence at least of deviancy, which may or may not be related to compulsiveness. And the factual context is different. However, if the board felt constrained, if the hearing examiner felt constrained by the board's regulation, then he or she may not have looked at that issue with the proper lens. So would that case have to be remanded?
Well, I think that one of the factual differences in this case is this individual knew what he was doing was wrong because he was, the girl had felt that he was threatening her about not telling anybody. So I think that gives it a little bit more of a, he knew he was wrong doing what he was doing and he still kept doing it. So I think in that situation, in this situation, there is no reason for a remand. And again, compulsiveness, I think at some point where the SJC is going to have to decide this. But until that time, I think that we can, safely follow the precepts of 22188 at this point, at least with this case. And I can see where there'd be cases where compulsiveness may or may not be proven based on the facts. But I think in this case, we have it, at least within the precepts of
You
22188.
understand that 22188 was remanded. We did not uphold what the board did.
Correct, but it wasn't remanded because of factor 2. It was remanded because it was a bad decision overall, if my memory serves me right. And unless there's other questions, I'm ready to rest.
I'm not seeing any, so I think we should leave it there.
Thank you, Your Honors.
Thank you both very much. Please.
We're live.
Thank you very much. We are back on the record with our final argument of the day, and it is 2019 P 1465 Tonsberg versus Lanza. These are cross appeals, but I believe Mr. Moriarty is going first.
Thank you, Your Honor. May it please the court, Thomas Moriarty for the defendants, Matthew and Jeanette Lanza. The defendants are not waiving any arguments they've advanced in any of their papers, but we are going to address two main points with regard to our argument this afternoon. First, the trial court judgment finding that the plaintiff demonstrated actual and substantial benefit from enforcement of the subject restriction should be reversed. And in the alternative, should this court determine that the enforcement of the restriction is appropriate, the trial court's remedy preventing use of the pool is within its sound discretion, and that remedy should be affirmed on appeal. First, Your Honor, the plaintiff was required to demonstrate actual and substantial benefit from enforcement of the covenant, and she did not.
You don't challenge the actual part, just the substantial part, correct?
That's correct, Your Honor. We express it the way the statute and the cases have expressed it as actual and substantial. The actual part is essentially established by the existence of the restriction itself, and the focus is on the substantial benefit, or from our perspective, the absence of substantial benefit. That comes right out of General Law 184, Section 30. And the plaintiff's argument that it need only show more than a de minimis benefit is not supported by Section 30 or the decisional case law. Furthermore, the trial court's finding on page 15 of its decision that the plaintiff need only show more than a trivial benefit is equally inaccurate. The law is clear, both in terms of the statute and in the cases interpreting the statute, that the plaintiff's obligation is to show actual and substantial benefit. And in this context, substantial means something involving substance, something material, where a party is seeking to enforce, obtains an advantage in kind with the objective the restriction is intended to address. One would be appropriate or correct in finding actual and substantial benefit. In this context, therefore, it is necessary for the court to determine what the objective is of the restriction and to keep that in.
Counsel, can I just stop you there?
Of course.
Isn't that a question of fact that the judge himself resolved? I understand that you're relying on the developer's statement that the purpose was to preserve the integrity of the golf course. But the developer went on to say that it also had benefits for the owners of the golf course lots. And the judge appears to have credited that explanation in full, so that his finding to that effect would not be clearly erroneous. Aren't you stuck with that?
Your Honor, the factual finding that the court made and employed was limited to the benefit to the golf course. There was factual testimony, and the court may have accepted that testimony, but that is not what the trial court relied on in making the finding of actual and substantial benefit. In fact, the trial court did not find actual and substantial benefit because there was a direct benefit in any way to the plaintiff in this case. So while that testimony was there, it's clear from the court's decision that the court's decision relied exclusively upon a presumed vicarious benefit from the golf course and developer that inured to the property owner.
Is vicarious a fair adjective? I mean, it may be derivative or it may be indirect, but vicarious suggests that you're just deeming something a benefit when it really goes to somebody else. Here, the judge seems to say, if it benefited the golf course in this respect, it would also benefit her.
Well, Your Honor, if the court is not comfortable with the term, obviously anything that conveys the substance of finding a benefit exclusively for the golf course and then transferring that benefit to the property owner without any demonstration that the golf course actually and substantially benefits from the enforcement of the restriction, or in addition, without any finding that the transferred benefit, which quite frankly, the defendants do believe is a vicarious benefit that flows through the developer and the golf course. But if that is not a fair expression of the concept, that transferred benefit was in and of itself actual and substantial to the property owner. So we say vicarious, Your Honor, the defendant says vicarious for two reasons. One, because there was no evidence that it was of actual and substantial benefit to the golf course. And then because whatever transferred benefit may have existed was not itself determined.
What do you do with the fact that the judge in his findings credited that she could hear the noises of children in the pool, and he credited that the activities bothered her? Isn't that a finding of a benefit to her from stopping those activities?
So we don't know, Your Honor, because the trial court did not rely on either fact to make a determination of actual and substantial benefit. It is possible that the trial court could have relied upon that fact, but that's not what's presented in the decision being reviewed on appeal. What we know is the court made that factual finding, but did not rely upon that factual finding in making a determination of actual and substantial benefit. It would
if what you are saying is true, are you arguing that we should then remand this for the judge to reconsider whether the impacts direct to her were substantial?
So the defendant's position is that a remand is not necessary because the facts are undisputed, and the defendant's position is, as a matter of law, the court can answer the question. And of course, from the defendant's perspective, the answer would be based on the evidence. It would be a determination that there is no actual and substantial benefit to the property owner. So we have suggested that this court has the ability to enter a reversal and a judgment for the defendants. Of course, if this court were to conclude that the factual record could arguably support a determination of actual and substantial, then I think the defendant will, I don't think, but I can say, Your Honor, that the defendants would concede that would have to be remanded for a determination. But it is the defendant's position that the decision can be reversed and that judgment can be entered because the factual record establishes that the plaintiff did not receive an actual and substantial benefit.
In the record, there are a lot of photographs. I think there's no photograph of the pool, but what are the photographs that you say depict the view to the Lanza's property, the pool?
Okay, so Your Honor, there are several photographs. I do not have the photographs, the pages of the photographs to point this court to. I will say, Your Honor, that none of the photographs are in any way relevant to the trial court's determination or this court's consideration on appeal, simply because, Your Honor, the plaintiff abandoned any claim in the trial court that it had suffered an actual and substantial, or would receive an actual and substantial benefit from an enforcement of the covenants relative to view. There is a somewhat of a tortuous history in the trial court with regard to those photographs, Your Honor, but the fact of the matter is the plaintiff clearly and absolutely abandoned any claim premised upon view in the trial court.
Well, can you look at it's Appendix Volume 4, Exhibit 74. Can you tell me what that is?
That's at page 102.
Yes. Appendix Volume 474 is a photograph of the building in which the plaintiff operates her salon. It is neither the Tonsberg nor the Lanza property.
So the gray area with something blue on it, that's not the pool construction area?
This is Record Volume Appendix 4 of 4, page 74.
It's Exhibit 74, but I think on the PDF, it's number 102.
I'm sorry, Your Honor, Exhibit 74. I have that. Page 102. That is a photograph of the Lanza pool, deck, and pool house.
Okay.
And it's just got a cover on it.
It does. It does. Your Honors, the trial court applies.
So just one question. When we're evaluating whether someone received a substantial benefit from this covenant not to have a pool, are we using a subjective standard or an objective standard?
So, Your Honor, it's an objective standard. Was there objectively an actual and substantial benefit? And it's the defendant's position that it is a burden of proof and not one of production.
Why isn't the judge right that when you have a common theme like this, you don't have to show much to get over the hump?
Well, only because the SJC and this court have said in the past that is not the case, Your Honor. The SJC's decision in Gulf Oil analyzes whether or not there was a common scheme, and then specifically goes on to say other considerations remain for disposition, noting that it was necessary to consider the restriction in light of the provisions of General Law 184, Section 30, in order to determine if the restriction should be enforced. And then what the court did was look actually at the physical enjoyment of the plaintiff's property. The same can be said of the Klein case, Your Honor. In Klein, the court analyzed whether there was a common scheme and then went on to say that the court must determine if the restriction is of actual and substantial benefit, citing Chapter 184, Section 30. In neither case, Your Honor, is there any suggestion that the burden imposed upon the plaintiff under 184, Section 30 is in any way reduced, that it must easily pass, or that somehow the standard is less than actual and substantial as established by the statute and the case law.
Okay, counsel, you said you wanted to get to the issue of remedy. There are 2 minutes left.
Thank you, Your Honor. As regards remedy, Your Honor, the basic premise and controlling premise is that the remedy is within the sound discretion of the trial court. In formulating this remedy, the trial court was empowered to determine what the injunction would be that resulted in an enforcement of the covenant. Contrary to what the plaintiffs are alleging, the court did not opt to award money damages. The court specifically enforced this provision. It specifically enforced the provision by ordering the Lanzas not to use the structure, to essentially put it beyond use.
So say there's a violation of the enjoining of the use, and the Tonsbergs bring that to the court's attention. could they seek contempt penalties, or what relevance, what import are these liquidated penalties set forth in the order, in the judgment?
I would say, Your Honor, they're a very limited import with regard to the scope of the plaintiff's relief. The plaintiff wants to make those money damages somehow a money damages relief in this case, but in reality, the court has ordered the Lanzas not to take this action. The full panoply of remedies available under the court's contempt power will be available to the court. The mere fact that there has been built into this decision some motivation on the part of the defendants not to violate the order does not deprive a court of the ability through its contempt powers to fashion a further remedy. If this decision were silent, if this judgment were silent with regard to the monetary penalty, there would be no question but that the court could further enforce this provision through the contempt powers of the court. It can, despite the existence of that monetary penalty, which might provide a check on a defendant in connection with a violation.
Okay, I have one very specific question, and then I'll check with my colleagues. Turning back to the terms of the restriction itself, it refers both to the golf course lots, which are defined by reference to individual lots, and it refers to lots adjacent to the golf course. And there are some suggestions in your brief that those are different sets. Those are not completely congruent. Is that right? Are there lots that are defined as golf course lots that are not in fact adjacent to the golf course?
Yes, Your Honor. So the example would be the Putter's Place project, the Putter's Place Homeowners Association. The court itself observed that those lots were in a little bit of a different position than was the Lanza lot.
Are those defined as golf course lots?
They are golf course lots, Your Honor. Every lot that circles what is known as the golf course or lot 4105, everyone that is adjacent to that lot is a golf course lot. But the golf course itself is not necessarily constructed out to the boundary of every one of those lots. So the golf course lot is a legal lot on which the golf course is constructed. But the golf course itself was not constructed to the boundary of each one of the golf course lots. So for instance, with Putter's Place, as the trial court observed, there is a distance between the actual golf course and the boundary of the Putter's Place lots.
So under your interpretation, then, a pool could be built at Putter's Place, on the lots on Putter's Place?
Yeah, absolutely, Your Honor.
Okay. Do my colleagues have any questions?
Yes, I just, if the Lanzas use the pool and the Tombergs know that and report it to the court, what happens?
Well, that would be again within the discretion of the trial court, but the contempt powers available to the trial court are very significant, and removal of the pool as a potential remedy for that violation would certainly be available to the trial court. But there could be other actions available as well. But the bottom line is that the court has very, very wide powers with regard to enforcing a trial court order.
Okay, thank you very much, counsel. We'll hear from your brother.
And thank you, Your Honors, and may it please the court. With respect to this issue of substantial benefit, the standard for which this appellate panel is reviewing this case is whether or not that finding was clearly erroneous based upon any evidence in the record itself. And in this case, you have as a part of the record appendix all of the testimony of the trial witnesses, including that of the plaintiff, Roberta Tonsberg. She gave specific evidence about, as Justice Milkey noted, about the quiet and the solitude of her backyard and seeing wildlife and whatnot. Now, it's true, the findings of fact don't specifically state what she said, but it's certainly fair to infer that the judge adopted it, because on page 16, first of all, he credited her testimony explicitly in the decision. Secondly, on page 16, he makes reference to the case of Connaughton versus Payne, which talks about much of the similar type of benefit that homeowner found in wanting to enforce a restriction. So I think to question whether or not the record is adequate to support the finding of substantial benefit, I think is plainly wrong. Second of all, picking up on the common scheme, invite the court, and I know you'll do this, to read all of the cases dealing with common scheme, including Gulf Oil, Harrod versus Rigglehout, Gilbert versus Repertory, Sterling Realty. These are all cited. And in all of those cases, they did an analysis to see if there's a common scheme. Where there was a common scheme, then the courts found, specifically in Gilbert, that the scheme constituted, in essence, an easement of pertinent. That, in other words, the restrictions imposed a burden on those lots that were subject to the restrictions, but also came with a benefit to allow any homeowner, any lot that owned, that was subject to those restrictions, to enforce those restrictions. So I think for those two reasons, the record below is more than adequate.
But counsel, aren't most of the common scheme cases, if not all of them, dealing with completely reciprocal restrictions that sort of apply to everyone, like, for example, height restrictions? I mean, here, this is somewhat unusual in that even though the purpose of the restriction may be more than serving the golf course, I think it's probably fair to say that the primary purpose was to protect the integrity of the golf course. So don't we have to look beyond the mere existence of the common scheme to answer that question?
I respectfully disagree with that notion, Justice Milkey, because there was evidence also from the real estate broker, Nancy Verda, that talks about the benefit and the panache of being in a country club atmosphere. And that I believe the terminology of the court was the cachet of that community still existed. And that's why, and that's a benefit that everyone has. And it could imply to some extent on just the value of the property, people wanting to live in a country club community.
Okay, but help me out on that. Let's say a bunch of third graders are playing Marco Polo right next to the fairway of the second hole, which annoys some golfers. How does that affect your client's the value she enjoys in her home, or the value she gets from living in a country club atmosphere, or whatever that is?
Well, because take Noyes as an example. She may not be playing golf, but she can still value being in a quiet neighborhood. I mean, she can enjoy it for a reason different than the golfers.
But those are direct benefits on her. I'm talking about the derivative benefits, which your brother argues is really primarily what the judge relied on in finding a substantial benefit.
Well, my brother used in his brief the word vicarious. I think I counted more than 15 times. That's a word that the court never used, the cases don't use, and I think that that's a contrivance by the Lanzes in putting this forth. What exists here is a set of restrictions including the no pool restrictions, to create a certain atmosphere. The very restrictions themselves say that they run with and bind the land, bind the owners of the land. So that's a contract principle in terms of benefits and burdens with respect to a contract. So the court's analysis, the trial court's analysis on this, and by the way, he did take a view of this property, found that it was a substantial benefit, is more than supported by the record. These restrictions, he found each of them to continue to be enforceable. The developer, who is also the golf course onswer, said that why they were put in and that they still had value there and meaning. And Mrs. Tonsberg testified that it has meaning for her. The noise, in addition just to the noise, it also scares away wildlife that exists along a golf course that she would otherwise see. So I think the fact that she may value it for reasons different than a golfer or the developer or the country club may have, I think is irrelevant. The question is whether or not the restrictions still have viability, and they do. And that testimony was universal throughout the entire case. There was no testimony to the contrary. With respect to this idea about the adequacy of the relief granted, I think it's clear. Every case that I've found that's reported, in every case, once they found that a restriction was enforceable, they issued a mandatory injunction. Now, the Lanzas argue that in Gulf Oil, they didn't require the buildings to be taken down, and that's true. But that's because the restriction in that case was a use restriction. It wasn't about the construction.
But counsel, the court here did enjoin the use of the pool. And then let me just finish.
Sure.
Assume for the sake of argument that the Lanzas comply with that injunction. Does your client suffer any harm whatsoever from a pool that's not used?
Well, for one thing, the order gives them right to access the pool for regular and normal maintenance. There would be no need to have maintenance if it's not being used as a pool. I think the point here is that if there's a pool, there is likelihood, particularly the way the relief has been fashioned. So it becomes a cost of having the pool. That if you use the pool, it's going to cost $100 a day per person using it. So the use of a pool in Massachusetts has.
Okay, but counsel, your brother says that is not binding on the trial court. The trial court could use its full contempt powers and, if appropriate, order them to remove the pool.
That's what we brought this case for. And that's what the mandatory injunctions, that's what all the reported cases from Gulf Oil to Harrod to Gilbert versus Repertory to Sterling Realty versus Trednick to Canty versus Donovan. They all say that once you do it, mandatory injunctions are the way to go. And in all those cases, it would be like saying, Judge, that a restriction that says only one-story buildings on the property to allow somebody to build a two-story building, but then saying you can't access that second story. Or in the Sterling Realty versus Trednick.
Isn't this different where it seems like your client was making a noise argument, and so if they managed to sneak and use the pool without so much noise as to alert your client, then her concerns are addressed and they get the use of the pool. So I don't quite understand. So it doesn't seem the same as the two-story, because the second story is there, it's visible, it's imposing on the other structures. Whereas here, it seems like what the judge has done, and I could be misreading this, but he's giving them an opportunity to use this pool as long as their noise level is so low she doesn't know.
That's exactly violates the restriction. If you find that the restrictions are enforceable, but allowing them to maintain the pool, in which is a no pool restriction, But to use it under low decibel levels, that completely abrogates the whole notion of a pool restriction. And
Why?
well, because that, for one thing, because the restriction is there. My client can't build a pool if there's a no pool restriction. She hasn't violated that. She's entitled under the law to enforce these other restrictions. So what if that means then that 5 other pools on these golf course lots are constructed? Then collectively, everybody can build them and violate the restriction so long as they use them in a quiet fashion. That totally rewrites the restriction. That's something that the law does not provide for. In each case, let's take the example of the Sterling Realty versus Tregnack. It says that you can't construct a garage on a lot without a dwelling place. Well, that would be like the court, and they constructed in that case. And in that case, the court ordered they had to remove the garage, because otherwise, if you allow them the structure to remain, but just that they can't use the garage, that totally undermines the notion of the restriction. And that's, you know, none of the cited cases.
Aren't we dealing with an abuse of discretion standard on the form of the related?
I don't think so. I think it's a matter of law. I don't think it's an abuse of discretion, because I think that the language of the restriction is plain. The court made a finding that the restrictions are enforceable, that she had an actual and substantial benefit, and that none of the defenses apply. And I think the motion judge admonished the Lanzes that if they go forward, it was at their risk for it to be removed. And I couldn't find a single case in which a restriction was violated, but they were allowed to maintain it so long as the use of that restriction was kept under a certain amount of noise. That would turn the whole common scheme would be turned on its head if that's the case.
Well, are you making any sort of argument that the way that this injunction is set up just keeps these people in a constant state of conflict?
These people being the Tonsbergs?
Parties. The Tonsbergs with the Lanzes.
Yes, absolutely. First of all, it imposes upon the Tonsbergs a duty that they shouldn't have to continue to undertake, which is to monitor the pool and to wonder where the noise is coming from and what the sources of that noise is. So it does put them in constant conflict. They've invested a substantial amount of money to enforce these restrictions. They've been found they have a meritorious case. The law requires that they be entitled to the relief that they've sought under these cases. Under the Gilbert versus Repertory case, what they argued about was the marquees that were constructed in violation of the restriction, and then the order said in any other structure, but there was no argument about another structure. So the appeals court cut it back to specifically talk about the marquees. What the Tonsbergs are arguing about are the pools. The Lanzes should remove the pool. And otherwise, yeah, they're going to be in a constant state of conflict. And the Tonsbergs just shouldn't be at the mercy of having to make serial cases because they feel that it's been violated.
But the
Why would
pool
it
house
not be enough? Go ahead.
The pool house and the fence can stay.
Yes, the court made findings on that.
You're not challenging that.
Well, we're not challenging that, no.
Why would it not be enough if the pool stayed, but it did not have water in it?
That would be a lot closer, Judge, because then it wouldn't be a pool. So I think a better argument would exist that there's not a pool there. So I hear that, but there is a safety issue. But if it gets drained and covered, I mean, there's a way of handling that. But then it's not a pool. I would agree with you, Justice Henry.
You can sum up in a minute, unless my colleagues have questions.
My summary is this: it's a very simple case. There's a plain restriction, no pools. Those restrictions were found to be enforceable, and the relief granted does not enforce that restriction, and that's what the law requires. I would ask that the judgment be upheld and that the full force of that restriction be enforced.
Hey, thank you both very much. We're done, except I'm going to give my quick version of my Fred Brown speech, which is, we don't see cases like this very often where the parties are fighting so hard and eloquently on where the stakes are relatively small. The possible exception is in the family law context. There is a lot of background noise in this case. Reading the trial transcript, I felt at times I was reading the screenplay from Succession season 4. We're not going to try to sort out that background noise. We're going to deal with the case as we find it. I personally am fascinated by this case, and we will not hesitate to resolve it on the record it is before us. That said, one of your clients, and quite arguably both of your clients, might be very unhappy with however we come out on this case. And to the extent that the parties have any inclination to resolve this feud, which I think goes frankly beyond the pool, you should obviously feel free to do that, but you should do so quickly, because we are not going to hesitate to do our job on the case. And with that, I will declare the case submitted, and thank you both very much.
Thank you, Your Honor.
Your Honor.